My lord, one item, my lord, regarding demolition. It is fixed on 10th, my lord. If it can be taken up tomorrow also, my lord.
Motion
Motion,
today.
my lord.
You are ready today?
Yes,
Today?
my lord.
Item number 17, I have filed affidavit in opposition to them on 5 years of
My lord, there is one urgent matter. We are in the process of filing. It's against Northern Coalfield, my lord. And we have participated in coal auction and
Item
time
number?
limit for deposit. It's unlisted, my lord. Unlisted, my lord. We are in the process of filing. Our EMD money will be forfeited if the matter will not be heard, my lord, because yesterday was the last day to make to
You want
deposit
the
the
matter to be moved today?
Yes, my lord.
Motion.
My lord. All right.
In respect of item number 1, not we have filed an affidavit on the amount of the execution of Insukia. I mean, permitted to call for that.
Item number 1.
Item number.
It's at 2 p.m.
That affidavit. Alright, there is a special meeting at 2. Can I be at the meeting 3?
No, don't worry. I have some other matters also at fixed at 2, which I'll give more precision.
The special DTC.
The matters pertaining to Nagaland. Yeah.
I'll find a time.
There is a listing of the orders metal lordship for next week lordship.
Order?
Orders metal lordship.
What order?
Earlier listed on 1925 lordship.
What order?
Lordship fixed for only 3 weeks lordship.
Huh?
Metal not listed since long days lordship.
Orders for what?
Lordship,
What matter?
Item lordship Puram of a meeting lordship. Society cooperative Puram lordship.
Cooperative society.
Yes, lordship.
Go to bench 5. This court doesn't take bench 5.
Sorry, lordship.
My lord, I pray for listing of a motion matter, my lord, pertaining to railway construction in Guwahati railway station. My lord,
Today,
There's a-
tomorrow, when do you want?
tomorrow, my lord, President.
My lord, similar prayer, my lord. Tomorrow.
Similar prayer, lordship. Similar prayer, lordship. Motion matter for tomorrow, your lordship.
Meet please your daughter. Meet please your daughter. Lordship, with the consent of the other side, I beg to mention item number 5, Lordship. My senior colleague is outside stage on that.
Item number 5.
Yes, Lord.
Is a Pathad, it's shown as Pathad.
Next week, any day, Lordship.
No. 2016 matter, no. Who is appearing?
I'm appearing for the petitioner.
Then?
They circulated one adjournment.
These
Yesterday.
adjournment slips doesn't have any value.
No, that's, I'm just referring to that.
You're ready with your matter?
Now, we had filed an affidavit
Fantastic.
tomorrow, lordship.
No? Both of you pay 10,000 each, then we'll have it tomorrow. Ready? No? Then do your matter.
Then I inform S. Gupta, Lordship.
What?
S. Gupta, Lordship. His name is there, Lordship, in this case.
8 Gupta. Very well. So, we'll take up the matter. The matter.
Please, your lordship. Lordship, I beg to mention 3 matters for listing for tomorrow admission, lordship. Similar matters were disposed of by your lordship. Non-payment of contractual bill. Same matter, lordship may dispose it of.
Non-payment of
Contractual
contractual
bills.
bills will go on 17th of November.
Much obliged.
WPC list for order. WPC list for order.
Orders. Orders for what?
WPC.
That I also know. Orders for what? What orders are you requiring? What is the matter about? First find out, then mention it tomorrow. Next.
Lordship, I beg to mention item number 6, lordship.
Item number?
Item number 6, lordship, Pathad matter, lordship. So, Arguing Council SG Borua is suffering from extreme personal difficulty, lordship. Lordship,
Who?
SG Borua, lordship.
Okay, we vacate the stay order.
Lordship.
Don't worry. If you are not in urgency, we vacate this.
Kindly adjourn for the day, lordship.
I'll adjourn it, don't. No problem. I'll adjourn it for signer there. But the fact remains that I'll vacate the stay order. There's a stay order, na? That day I passed an interim order.
In the.
We vacate that. Either do it or vacate.
Lordship.
Please, lordship.
Lordship, I beg to mention one IA for listing. In
Aye?
one IA for listing.
IA for list. What IA for?
Lordship, in regard to condonation of delay.
Condonation of delay here.
Uh, Lordship, in connection with one review petition.
Then
Lordship, during
review
the,
petition, IA, condonation of delay is required in a writ petition. I'm asking you. If it is required, you have filed a review petition.
Lordship.
Ask for review petition for listing. If you have filed the IA will commit.
Lordship, in of the review petition, we have only the filing numbers. Because the day before yesterday, we have filed the review petition.
Okay. Ask for the review petition
Lordship.
for the listing of the review petition. When do you want it?
Lordship, tomorrow or the day after tomorrow.
Why?
Lordship,
after-
during the pendency, the respondent prepare to conduct the election.
Election of what?
Election of Samawai Committee. Cooperative Society.
Is it a bench 4 matter? I don't take up Samawai Samiti matter. Do I take? Yes, do I take the Samawai? Samawai Samiti is under what? Panchayat? So cooperative it will be bench 5, don't you think? Or it's a review of my judgment? Is it my judgment?
Lordship, I have.
Is it my judgment?
Lordship, I,
You find out, then mention at 2.
Lordship.
Find out.
Supplementary list, proposed list item 11 to 15.
Yes, who is arguing for PhD?
This, I'll get it.
Okay, tell me why he is not entitled to the interest. Why the petitioner is not entitled to the interest in terms with section 16 and 17 of the MSC. The fact that you have paid during the pendency of the writ petition, the amount is not in doubt. It is an admitted fact. You further admit that particular amount. You have also earlier given a calculation as on 31/3/2019 that this is the particular interest payable as per the MSME Act. Then why should this court, in exercise of powers under Article 226, should not direct you for due compliance in terms with section 16 and 17, which is the mandate of law?
Admitted the amount. Should the amount has been admitted during the pendency, even the principal amount was already paid.
Understood. But what about the interest? That is
That is
the
issue.
only issue as section 16 and 17.
That's it.
Now tell me why the petitioner is not entitled to the interest in terms with section 16 and 17.
Your Lordship, at this point, Your Lordship, what happened is that at that point of time, when the works were executed, whether the petitioner was a registered MSME at that point of time, that has to be ascertained by the authorities, Your Lordship. That has to be ascertained by the authorities. At that point, when the work, exactly at that point, when the works were executed.
When was the work executed?
Lordship, you gave a chart.
The year 2000. 14. Different works, Your Lordship, 11, 12, 13, 14. 14, 15.
2011
There were 11, the works orders.
work order. Give me the work order. We are taking up 4631. What is the work order? Date?
In 4631, your lordship, work orders are 2014 and 15.
Huh?
Work orders were of 2014 and 15. 4631.
Page?
They have given us, you get the-
I'll give it a charge in my petition.
Page? Yeah,
My change.
5/10/2015, page 76. Isn't it?
At page 13, I've given the chart.
Page 13, you have
13.
given the chart. Yes, these are the work orders.
Yes, sir.
2014, 15, all these are 14 and 15.
Yes, sir.
Now the question is as to whether it was an MSME
At that
at that
particular
point of
point of
time.
time. Oh, so that's the issue we are facing
Yes,
now.
that is the issue.
That's the issue.
Now let us see, the petitioner have enclosed out here with her writ petition. The EM registration,
Page 57.
lecture 4, page 57. It is 1/3/2014,
13140.
okay? Then the petitioner had also filed another additional affidavit filed on four 9/2025, wherein the manner in which the amount, manner in which a registration has been done has been duly mentioned. So here the petitioner has an EM registration on 1/3/2014, page 57. Now kindly come to the additional affidavit filed on 4th of September 2025. Because earlier when this court heard this matter, I put a specific question upon the counsel for the petition. That in terms with the MSME Act, there is a requirement that if you have an EM registration, that memorandum has to be also filed so that you can be given the MSME certificate. Okay, now there, pursuant thereto, this particular document affidavit has been filed. Have you gone through this affidavit filed on 4/9/2025?
49.
But give it back.
Okay, sir. Yes, a lot.
Huh? Read it. From paragraph 3.
The bonus states that in order to promote the small local industries in Assam, the government of Assam enacted the Assam Preferential Store Purchase Act 1989, which came to force on 14 July 1989 with the objective of fostering industrial growth in Assam, particularly by encouraging small scale and cottage industry. The act provides for preferential purchase status to certain listed items at price fixed by the technical committee under the act and made it obligatory for the state government. Obligatory for state government departments, government companies, and state government undertakings to purchase the said items of small scale local industries. That the goods manufactured by the petitioners falls in Schedule 1 and Schedule 3 of the APSC Act 1989, and the petitioner comes to register as an SSI unit under the Assam Small Industrial Development Corporation Limited, and was also registered under the APSC Act. In order to further protect the small scale industries, on 2nd April 1903, the government of India enacted the interest on delayed payments to small scale and ancillary industrial undertaking 1993. But provided for payments of interest in case of delay in payments of bills by the buyers. In the year 2006, the Micro, Small, Medium Enterprise Development came into effect by virtue of Section 32 of the MSME Act. The interest on claim payment to small scale and ancillary industries undertaken in 3 was repealed. The MSME Act, being non-regulatory in nature, was enacted to facilitate the growth of the MSME sector across India and to provide protection by ensuring timely payments of MSMEs. That the MSME Act provided for payment of interest in case of delay in making payments, and payment of such interest becomes statutory liability vis-a-vis the buyers. However, the MSME Act in respect of preferential procurement of good manufactured small scale industries left the entire matter to the respective state and central government. Under section 11 of the Act, and the state government or the central government was
MSME
notified.
Act.
The preferential policies for procurement of goods and services produced and provided micro and small enterprise by its minister and department, its aided institution and public sector enterprises. That previously the procurement for the micro and small scale industries are done as per provision of the APSCP Act. Thereafter, in October 2015, the APSCP Act was repealed and was replaced by the procurement preference policy of the Assam 2015 in terms of section 11 of the MSME Act. The section 8(1) of the MSME Act deals with memorandum micro, small, and medium enterprise. Hereunto referred as
This is very relevant, section 8. Now you go through it.
the memorandum of micro, small, and medium enterprises. Any person who intends to establish a micro, small enterprise may at his discretion, or medium enterprise engage in providing or rendering of service may at his discretion, or a medium enterprise engage in the manufacture or production of goods pertaining to any industry specified in the first schedule of the Industries Development and Regulation 1951 shall file the memorandum of micro, small, or as the case may be of medium enterprise with such authority as may be specified by the state government under subsection 4 or central government under section 3. The Ministry of Small Scale New Delhi issued a notification on 29/9/2006 and exercised the power under subsection 2, section 8 of the MSME Act. The schedule to the state notification provided the procedure of filing entrepreneur memorandum.
That's the EM,
That's the EM.
which is at page 57.
The notification dated 29/9/2006. In its schedule 2, the procedure of filing of entrepreneur's memorandum is given. The schedule 2 of the notification given below is: number 1, form of the entrepreneur's memorandum can be downloaded from the internet, the address of which can be obtained from directorate dealing with the micro, small, and medium enterprises, state government, or the union territories, or the hard copies of the same can be obtained from district industry centers. This form can also be downloaded from Small Industry Development Organization website. Any person who intends to establish a micro or small enterprise in his discretion, or a medium enterprise engaged in providing or rendering of service may, at his discretion, or a medium enterprise engaged in the manufacture or production of goods shall file a memorandum micro and small, or as the case may be, of medium enterprise with district industry center of its area. The district industry center shall file the codes in the form of memorandum and issue an acknowledgement after allotting any entrepreneur memorandum number, date of issues, and category of the unit within 5 days of receipt of the memorandum by post or the same. It is if the form of memorandum submitted in person as well as online. Before issuing acknowledgement, district industry center shall make sure that the form is complete in all respects, and particularly the form is signed and is accompanied with an undertaking which is a part of form of entrepreneur memorandum.
Now, at this stage, let us again come to page 57. So-and-so has filed memorandum for manufacturing enterprise at so-and-so for its items below, and activities has commenced from 8/2 as stated in the form, and allocated entrepreneur memorandum number as below. So-and-so number has been given. So this is in compliance with 3 and 4.
3 and 4.
Now come further.
The district industry center shall maintain record of all the entrepreneurs memorandum so filed in respect of micro, small, and medium enterprises engaged in providing and rendering services. District industry center shall forward a copy of the entrepreneurs memorandum so filed with the entrepreneur memorandum allotted to the small industry service institutes of their state or their jurisdiction. The district industry center shall maintain record of all the entrepreneurs memorandum so filed in respect of medium enterprises engage in production or manufacturing of products, and forward 1 copy each of the entrepreneurs memorandum with entrepreneurs memorandum number allotted to small industry service institute of the state or the jurisdiction, and the Joint Development Commissioner Micro, Small, Medium Enterprise Policy in the Office of Development Commissioner Small Scale Industries. The former memorandum is in two parts. Any person who intend to establish a micro, small, and medium enterprise engaged in providing or rendering service may file, or those who want to establish medium enterprise engaged in production of or manufacture products shall file Part 1 the entrepreneur memorandum to District Industry Center. Once above production or start, once above enterprises start production or start providing the rendering service, they shall file Part 2 of the entrepreneur memorandum to District Industry Center. In case of non-filing of Part 2 of the entrepreneur's memorandum, within 2 years of filing Part 1, the memorandum filed by the entrepreneur will become invalid. In case of change in investment in plant and machinery or in equipment, the enterprises who have already filed entrepreneurs memorandum
Now,
should
therefore, Mr. Again, you come back to page 57. You see, this is EM Part 2.
EM Part 2.
EM Part 2, and it has been mentioned that it is filed, they have commenced production on 8/2/2014. And it is EM Part.
EM Part 2. In case of change in investment in plant and machinery or in equipment, enterprises who have already filed entrepreneurs memorandum should inform the District Industry Center of the same in writing within 3 months of the change in investment. In case of change of products and there are service or addition in products or service, the enterprise which have already filed entrepreneurs memorandum shall inform the district industries of the same in writing within 3 months of the change. The District Industry Center shall, in addition of keeping a record in writing, shall also maintain records electronically on computer.
Now, the change in the investment is being mentioned, taking into account that each of the different medium, small, micro, small, and medium has different investment value. So if it is a small micro, then they have to mention that. If it is small, it has to be mentioned. And then now, as per the latest thing, which has come up only recently in the year April 2025, for the purpose of small, it will be now 5 crores. But anyway, now let us further go to the 12.
Thereafter, the Ministry of Micro, Small and Medium Enterprises issued another notification dated 1/8/2007, clarifying section 8(1) of the Act, stating that filing of the EM within the 180-day limitation is voluntary. An enterprise can file EM anytime they decide to do so. The notification further states that the MSMED Act is facilitatory in nature and not regulatory. As per the procurement policy, any MSE who has obtained an EM Part 2 from District Industries and Commerce Center shall be eligible for registration under the policy. Registration shall be valid for 2 years and will be reviewed and renewed after every 2 years by the various continuous commercial and technical competence of registration micro and small enterprises. The General Manager, DI and CC will issue registration certificate under the policy, which was done in the case of petitioner, and the petitioner was duly registered firstly under the MSMED Act and thereafter under procurement policy of 2015.
Now, this is the notification annexure A. Now, kindly come to page 365.
Filing of entrepreneurs memorandum by medium enterprises. The provided section 8(1) of the Micro, Small and Medium Enterprises Development Act 2006 contains that an industry having an investment in plant and machinery for more than 100 crores, but not
1 crore.
1 crore, but not exceeding 10 crores, which had filed industrial entrepreneur memorandum with Department of IP&P in person notification number so-and-so dated July 5th, 1991, shall file the EM within District Industry Center concerned with 180 days from the commencement of the Act. However, number of clarifications have been sought whether such enterprises which have not filed the EM within 180 days of commencement of the Act can be allowed to file EM. MSMED Act under Section 31 empowers the central government to remove any difficulty that may arise in giving effect to provision of this Act by making an order to its effect. However, it may not be necessary to take recourse to the provision of Section 31, since a closer reading of the proviso Section 8(1) reveals that there is no bar on the cited enterprises investment in P&M more than 1 crore, but not exceeding 10 crore, etc., from filing the EM, which they were enjoined to do so within 180 days of 2nd October 2006. That being the case, enterprises may prompt to file this memorandum at least now. In fact, the state government through the DICs could be requested to inform such enterprises that they must file such EMs expeditiously. It is worth mentioning here that MSMED Act is facilitated not in regulatory nature.
Summary.
To summarize the whole issue,
Therefore, now come to section 8.
section it reads, Your Lordship, memorandum.
Any person who intends to establish, let us omit the bypass A, B, C, shall file the memorandum of micro, small as the case may be of the demand with such authority as may be specified by the state government under subsection 4 of section demand. Provided that any person who before the commencement of this act established a small scale industry and obtained registration certificate may at his discretion engage so and so shall file within 100 days from the date of commencement of the file the memorandum in accordance with the provisions of the act. Now, this is being taken care of by that notification in view of section 31 of the act. The form of memorandum, the procedure of its filing and other matters incidental thereto shall be as notified. So this is the notification given as per section in the 2006. The authority with which the memorandum shall be filed by the medium enterprise shall be such as may be specified by the state government by notification specify the authority with which a micro or small industry may file the memorandum. The authority specified under so and so shall follow the purpose of so and so. So therefore, he has the petitioner herein has the EM memorandum given under part 2.
Part 2.
And this, what has happened initially, if it was already an industry, then it ought to have been filed within 180 days. But it was not filed within 180 days. But in view of that notification, it is not necessary. But be that as it may, as on 1/3/2014, the petitioner had an MSME registration in view of the filing of EM Part 2. Now, recently, there has been a further amendment which requires now that you have to also get it done out there in some Adhyam or Udyam something. Udyam, and then you are given an MSME certificate, which the petitioner has now. Now, the question is therefore, at that point of time, whether the law mandated that the petitioner being a micro or a small or a medium enterprise would be entitled to interest, irrespective of you mentioning it in the work order or not. So for that, you need to see section 16. Let us see section 16.
Let me read, Your Lordship.
Yes, please.
Section 16.
Let us see paragraph, section 15 also.
Really.
Delayed payments to micro and small enterprise.
Section 15 says liability of buyers to make payment. When any supplier supplies any good or renders any service to any buyer, the buyer shall make payments thereof on or before the date agreed between him and the supplier in writing, or where there is no agreement in behalf before the appointed date. Provided that in no case the period agreed upon between the supplier and the buyer in writing shall exceed 45 days on day of acceptance or the day of being acceptance.
Appointed day means section 2B, the day following immediately after the expiry of 15 days from the date of acceptance or the day of deemed acceptance of any goods or any services by the buyer. This is defined in 2B. So you are to therefore either on or before the date agreed upon, you pay, and between him and the supplier in writing, or where there is no agreement, then within 15
Well, 15.
from the date the goods have been accepted. Provided that in no case the period agreed upon between the buyer and a year shall exceed 45 days from the date of acceptance or the day of deemed acceptance. So even if there is an agreement saying that it will be paid after 60 days, this is by way of the proviso, it is statutorily overridden. So if you have a term out there saying that, okay, We are going to have it, we'll make, after acceptance, we'll make it after 70 days or 90 days. By virtue of this proviso, it is overridden. Isn't it? Okay, now let us come to 16.
Section 16, your lordship says, date from which a rate at which interest is payable. When any buyer fails to make payment of the amount to supplier as required under section 15, the buyer shall, notwithstanding anything contained in the agreement between the buyers and suppliers or in any law.
Or in any law for the time being enforced. So it not only overrides an agreement, but also any other law.
Any other law.
Unless you have a law subsequent to 2006, which mandates otherwise.
Yes.
Be liable to pay compound interest with monthly rest to the supplier on that amount from the appointed day, or as the case may be from the date immediately following the date agreed upon, at least at 3 times the bank rate notified by the Reserve Bank. So your payment with monthly rest means, so it will be compounded as such. Just for example, 100 rupees with 21% interest. If it is so, per month would be different. So per month will be, let us assume, take a simpler, more example. Let us take at 12%, 24%. Per month, it will be 2%. So 100 rupees, 2%, it becomes 102 in the month of January. For the month of February, that 2% would be taken on that at 102, not 100.
Yes.
So with monthly risks. So therefore, it continues to accrue in such a manner. Let us see now section 17.
Section 17, recovery of amount. For any goods supplied or service rendered by the supplier, the buyer shall be liable to pay the amount with interest thereon as provided under section 16.
So this is 16. So this is now the statutory mandate. Now, you, on the last occasion, Mr. I. Thakur said about section 18. Read them.
Reference to micro and small enterprise facilitation council. Notwithstanding anything contained in any other law for a time being in force, any part could dispute me with regard to any amount due under section 17, make a reference to micro and small enterprise facilitation council. Or receive a reference under subsection 1, the council shall either itself conduct conciliation in the matter or seek the assistance of any institution or center providing alternate dispute resolution service by making a reference to such an institutional center for conducting conciliation and the provision of section 65 to 81 of the Arbitration Conciliation Act
No,
1996.
No, this has changed. This is now, we have, there is an amendment, you are reading an old act. On receipt of a reference under subsection 1, the council shall either conduct mediation itself or refer the matter to any mediation service provider as provided under the Mediation Act 2023. The conduct of the mediation under this section shall be as per the provisions of the Mediation Act 2023. Where the mediation initiated under subsection 3 is not successful and stands terminated without any settlement between the parties, the council shall either itself take out the dispute for arbitration or refer it to an institution or center providing alternative dispute resolution service for such arbitration, and provisions of the arbitration area shall then apply to the dispute as if the arbitration was in pursuance to an arbitration agreement referred to so and so. Notwithstanding anything contained in any other law for the time being in force, the micro so and so facility or the center providing alternatives shall have the jurisdiction to act as an arbitrator or mediator under this section in a dispute between the supplier located within its jurisdiction and a buyer located anywhere. Then an application, no application for setting aside any decree, award or so and so by the council itself or by any institution or center providing alternative dispute to which a reference is made by the council shall be entertained by any court unless the appellant has deposited with it 75% of the amount in terms with the decree awarded, or as the case may be, the two other order in the manner directed by so and so. Provided that pending disposal of ER to set aside the decree, the court shall order that such percentage of ER shall be paid to the supplier as it's considered reasonable within the circumstances. So therefore, this is the alternative remedy. The petitioner could very well go, but taking into account that the matter has been pending out here, wherein all these things have been taken note of, if the facts are admitted, is it required for this court now to relegate them to the MSCB council when the statute mandates that you are to pay the interest at this?
Issue is that even if the board.
Therefore,
75%
Mr. Gogoi,
deposit.
Mr. Gogoi, your other co-counsel, Mr. Gogoi, failed to understand
That's true, Your Lord.
why this court sent it for some form of a compromise.
Exactly, Your Lord.
That is the reason, because the amount otherwise is going to be, now with the compromise, you are going to pay an additional amount of 25 crores. Without the conciliation, without the mediation, the amount goes further beyond. But you have not taken it lightly. You have taken it very lightly.
No,
You have come up by your counsel or the additional chief secretary, whoever has done it, have done it in such a manner that, okay, we are going to take the risk. But do you know the fallout? Is this particular person going to pay from his own pocket the additional interest which is being accrued every time? Then
That's true, Your Lordship. So if I may put one, submit a lordship, what happened is that when the mediation took place, there was no any formal meeting, as I've been informed, that.
the formal meeting was made on the basis of an order passed by this court
Yes.
directing both the parties to appear before the additional chief secretary and do it.
And they appeared, Your Lordship.
They definitely appeared, but what letter you have produced on the last occasion was not in consonance with what has been submitted.
Because-
Mr. D. Gogoi had the audacity to submit before this court that his co-counsel had made an incorrect submission. And today he doesn't have he has not appeared before this court. Therefore, Mr. Gogoi, you have to also understand that I ask why Mr. D. Gogoi is not before this court. Because tomorrow again, if I pass an order upon your submission, he will come up with the same thing, that we never said so. He was never instructed to do so. Isn't it? Then, is this the conduct of a council?
It shouldn't be, Your Lordship.
I have nothing to do, but he had definitely blamed Mr. Ibotaku on that day. This was not sought for. Amongst your team, isn't Mr. Ibotaku the youngest?
Yes.
Then he had submitted what he could do before this court. And it is under such circumstances, this court passed an order taking into account that the phenomenal interest which is the state would have to pay. But they are not bothered. And it is not the case that you are not paying to others. Others you are doing it. But it is only the case of the petitioners you have not done that. Taking up lame excuses. Let this matter go to the mediation. Then you see what would the effect. There are 3-4 matters which I dealt with, which went to the mediation. And there was no payment. Was those your matters, madam?
No, there was Sahiwala's matters, I think. I think Sahiwala's matters.
No, there were some matters where there were direction to make payments. There was an award being passed. Was it your matters or whose?
No, my matters.
There also I passed certain order.
One.
Now, there was an award passed
In one of my
where
matters,
they have PHC agreed that I am going to pay this. And therefore, there was a direction passed by the mediation. They have asked them to come over. And then they are not paying, for which the writ petition was filed. They raised the issue why they don't go to the execution. That was the issue.
yes,
I said that, have you challenged it under 34? I remember that matter. Mr. P.N. Goswami appeared in that matter. So, Now you take this judgment, which is apparently on the face of it, and then blame it for the people, to those people. And I put it in my judgment that they blame it on those persons who are responsible and deducted. The state will have to take action against those persons who have done this thing. Because you see, after all, this money which you are going to pay as interest at this rate is all because of the fault on the part of the department. And this court further fails to understand that when did the AFRBM Act come in? 2000? 2000. After 2005, isn't it the mandate that you cannot issue a work order without having the finance? That why on earth you have not made these payments? And it has resulted in a litigation which is spanning for the last 11 years, 10 years. Isn't those officers responsible that the state had to bear this additional expenditure? Hello, I think we dictate them. You have that judgment on alternative remedy?
I didn't bring it, Lordship. I'll get it. It's not always a bar when it's long pending. When it's long pending, the question of pushing it to the appellate alternative, and it's not always a bar. That judgment, Lordship, talking about. I'll just get it.
What is that? What is
I'll
that
get it. I'll
judgment?
get it. I'll ask him to get it. Alternative remedy, not a bad. We have it in the, my notice there.
Okay, let me help you out.
I just.
Isn't that the judgment EIR 1971 SC, page 33? Then you have the Godrej Sarali judgment, wherein the 5 parameters have been laid down, that it is not required to be sent to the statutory authority if the court can very well deal with that issue after the matter has been pending.
For more than.
And it is a legal issue being raised, nothing on factual. Godrej Sarali and this. And the most important judgment is of the judgment of the year 1991. It is a judgment pertaining to some bank.
Constraint. 1998, it is CC1. So.
Heard Mrs. M. Hazarika, the learned senior counsel, assisted by Mr. D. Khan, appearing on behalf of the petitioners in the present batch of petitions. Mr. R. R. Gogoi appears on behalf of the Public Health Engineering Department of the Government of Assam. And Mr. Asul here appears on behalf of the Finance Department. All these four petitions raises common question of law. And as such, they are taken up for disposal by this common judgment and order. However, in order to specify the entitlement of the petitioners in the three, how many petition? Three
The three petitions.
of the petitioners in the three petitions. This court finds it relevant to take note of the facts which led to the filing of the writ petitions. WPC number 4631 of 2023. The petitioner herein, number one herein, is a proprietary firm belonging to the petitioner number two. The said petitioner are engaged in the business of manufacturing, amongst others, UPVC pipes and fittings, direct action hand pumps, casing pipes, rib screens, etc. When did you set up your business?
2014, the first one in 2014.
So you were registered under that preferential scheme.
Yes, because. Guide. 2014. All the petitions were registered under that. How can the other one take up?
The petitioner's industry was duly registered under the Assam Preferential Stores Purchase Act 1989 and was granted a registration certificate on 4/2/2014 bearing registration number DICC/KMRP/APSP/6088. The petitioner also applied for registration in terms with a notification dated 29/9/2006 issued by the Ministry of Small Scale Industries, New Delhi, and thereupon and submitted the form of entrepreneur memorandum as was required. The materials on record show that the petitioner commenced activities of manufacturing from 8/2/2014 and thereupon was issued an Entrepreneur Memorandum Part 2 on 1/3/2014. It is relevant to take note of that from the materials on record, it is seen that the petitioner was registered as a small scale industries, first under the Assam Preferential Store Purchase Act 1989.
Yes.
And thereupon, under the Micro, Small, Medium Enterprises Development Act 2006, for short, the Act of 2006. It may not be out of place to take note of that the Assam Preferential Stores Purchase Act 1989 was repealed by the Repealing Act
2014.
Assam Repealing Act of 2015. And thereupon, the state of Assam enacted the Assam Public Procurement. What is that act name?
Assam Preferential
Eh.
Public Procurement Policy.
And thereupon, the state of Assam announced the policy in the name and style of the Assam Procurement Preference Policy, Assam,
Yes.
Procurement Preference Policy, Assam, 2015. The materials on record show that the petitioners herein were issued various work orders by the PHE Department of the Government of Assam. The details of the said work orders have been mentioned in paragraph number 18 of the writ petition, and a chart given therein is reproduced hereunder, page 13 and 14 of this. It is the case of the petitioners that the petitioners duly executed the said work to the satisfaction of the concern. And bills were duly passed, but complete payments were not made to the petitioner. In spite of the same being confirmed by the PHE department. Under such circumstances, the petitioner filed a writ petition before this court, which was registered and numbered as WPC number 6045/2018. This court, by an order dated 5/9/2018, disposed of the said writ petition. With a direction to the Chief Engineer PHE to consider the representation so submitted by the petitioner on 9/7/2018 for making payment of the outstanding dues with interest within a period of 3 months from the date of receipt of the certified copy. The said order so passed by this court on 5/9/2018 in WPC number 6045/2018, having not been complied with, resulted in initiation of a proceedings under the Contempt of Court Act 1971, which was registered and numbered as contempt case number 101/2019. It is very pertinent herein to take note of that in the said contempt proceedings, the petitioner was directed in the contempt proceedings, an additional affidavit was filed by the petitioners in the said contempt proceedings, wherein it was alleged that the petitioners were forced into signing a memorandum of understanding with the government of Assam on certain terms and conditions. The said memorandum of understanding was also enclosed to the said additional affidavit. The said the co- the said memorandum of understanding so entered into bind between the petitioner as well as the respondent PhD department is relevant for the purpose of the present dispute. And as such, the same is reproduced herein under page 109. From the above quoted contents of the memorandum of understanding dated 14/5/2019, it is seen that the PhD department of the government of Assam had agreed to pay the petitioner the sum due in terms with the agreement, which was assessed at rupees 42,56,645 as on 14/5/2019, and additionally, an amount as calculated up to 31/3/2019 is payable by the department towards interest to the petitioner. It is further seen from the materials on record that on 19/12/2019, a communication was issued by the Chief Engineer PHE, Assam, to the petitioner in connection with the contempt proceeding initiated by the petitioner. Acknowledging that an amount of rupees 44,42,703 stating therein that an amount of rupees 44,42,703 had already been paid to the petitioner. And in respect to further claim of the outstanding, if any, which is denied and disputed by the department, the petitioner was given the liberty to make a reference to the Micro and Small Enterprise Facilitation Center as per Section 18 of the Act of 2006. The records further reveal that despite the said communication issued by the chief engineer, PHE, the contempt proceedings continued to be taken up by the learned coordinate bench of the court. This board further finds it relevant to take note of an additional affidavit filed by the chief engineer PhD in the contempt proceedings sometime in the month of February 2021.
This is even India from doesn't.
Wherein, referring to the communication dated 19/12/2019, it was categorically mentioned that the department had already decided to approach the MSME Facilitation Council for necessary arbitration, and proposal had been submitted to the government for permission. It was also mentioned that such steps were being taken so as to explore the scope of mediation as contemplated under Section 18, which shall save huge amount of public money. It was also mentioned that the respondent PhD department had also made a proposal for a supplementary budget to the tune of rupees 2,000 lakhs under the head of account to meet the liability against the state share for NWQSM scheme. Out of the said amount, 941.33595 lakhs have been proposed for payment of the outstanding principal amount against various courts of the contempt of court cases. And an amount of rupees 4,554.82381 lakhs have been proposed under the head of account for payment of outstanding interest amount against various courts of the contempt of courts cases. Further to that, the department had already placed supplementary demand to the government on 17/12/2020 for an amount of rupees 12196.15976 lakh, along with documents related to court cases. In the said affidavit, a statement was enclosed. Wherein it was shown that in respect to the supplies made by the petitioner, the amount so payable from the central account, that is NRDWP, of an amount of rupees 44,42,703 have already been paid. However, an amount of rupees 62,33,61,618, which was the state's liability, remained balanced. And the interest up to 30 November 2020, 2020 or 2000 or 2020, na? 2020 was rupees 455,79,715. Therefore, it would be seen that what had been stated in the communication dated 19/12/2019 by the Chief Engineer PHE regarding payment of rupees 44,42,703 was only in respect to the central government share and not the payment which ought to have been made from the state share, which was to the tune of rupees 62,33,618. In the said contempt proceedings, the petitioner also filed another affidavit in reply to the affidavit filed by the Chief Engineer, Public Health Engineering Department, wherein, amongst others, it was mentioned that the respondent department have made interest payment to the other parties in terms with the MSME Act of 2006, and the details were given in Annexure A to the said affidavit. Where is annexure 31?
Latest calculation. Page number 296.
Page 296, Kapsha. Annexure 31.
That's the current calculation.
Hmm?
Latest calculation.
Whose calculation? It's 31. When did you find it? When did you find it?
This petition, the last annexure, latest calculation.
It is further seen that that during the pendency of the said contempt proceeding,
Their calculation. We didn't.
a speaking order was passed on 27/4/2023. Wherein it duly acknowledged that the PHE department was liable to make the payment of rupees 62,33,618. But held that the petitioner herein was not entitled to any additional interest in view of the memorandum of understanding dated 14/5/2019. And also because it could not be ascertained whether the petitioner was in possession of a valid MSME registration certificate as was required under the Act of 2006 at the time when the work orders were awarded and executed by it. It was also mentioned that it could not be ascertained if the petitioner had duly disclosed its status as an MSME entity while the said work was allotted to it. Be that as it may, in the impugned order, in the order dated 27/4/2023, it was categorically admitted that the amount of rupees 62,33,618 was payable to the petitioner as principal amount due under the state sector, which shall be immediately paid upon receipt of the funds. The petitioner being aggrieved had filed the present petition, therefore assailing the order dated 27/4/2023, as well as seeking appropriate directions for payment of the amount of rupees 62,33,618 and the applicable interest in terms with the Act of 2006. Come back. Anything more to be stated in your facts?
My facts, no really, except that that this order which has been passed, it actually falls on record. That is that I have made.
Huh?
False, it's incorrect. The order which I have is factually incorrect. I've stated that. That lordship is evident from the facts.
No, that I'm dealing it. Now,
Yes.
anything more is to be
These are-
stated in the facts.
These are the only facts.
These are the facts.
Facts.
So anything else? So now therefore I'll take up the other two writ petition. That before going into the stand of the respondents in the WPC number 4361/2023, this court finds it relevant to state the facts also in the cases in the other two writ petition. For the WPC number 5273/2020.
SRK. Huh? Second is SRK and FICA.
No, right now we told 5273.
Mentioned that some amount was paid. You mentioned some amount was paid.
The facts of the present case are also similar. The facts in WPC number 4631/2023.
And one article.
Here there is no order passed. Order passed.
And Mr.
In as much as the respondents herein, respondents in the PhD department, had also are similar to the facts in WPC number 4631/2023. As well as the relief so sought for are also similar. In the instant case, the impugned speaking order is also dated 27/4/2023. Wherein also the respondent PhD duly admitted that an amount of rupees 32,44,879 was payable to the petitioner and rejected the contention on the ground of interest. In view of the memorandum of understanding dated 14/5/2019, bracketed here, similarly worded to the memorandum of understanding entered into by and between the PhD department with the petitioner in WPC number 4631/2023, bracket closed. And also because it could not be ascertained whether the petitioner was in possession of a valid MSME registration certificate as required under the Act of 2006 when the work was awarded and executed. And it could not also be ascertained if the SRK, if the petitioner had duly disclosed his status as an MSME entity whilst the state work was allotted to it. It is This court, however, finds it very pertinent to take note of that the petitioner in the present writ proceedings is a company registered under the provisions of the Companies Act 1956. And was duly registered under the Assam Preferential Store Purchase Act 1989 and was issued a registration certificate on 17/11/2009 bearing registration number DIC/KMRP/APSP/5796. The EM, the Entrepreneur Memorandum, Part 2. Was issued on
29/10/2009.
hmm,
29/10/2009.
where is that?
That's at page 56, Lordship.
Hmm?
Page 56.
56.
56.
29/10/2009. Wherein it is duly mentioned that the petitioner had commenced its activity from 22/10/2009. It is also pertinent to observe that even in the registration certificate issued on 29/10/2020, it has been duly mentioned that 18/10/2009 is the date for registration of the enterprise. And the date of commencement of production of the business to be 22/10/2009. WPC number 5966 of the.
Lordship, in this case, I just have to point out to Lordship that we received one part of the interest amounting to 1,54,00,000 was paid to us. So that was only a part.
Yeah,
I've made it mentioned in my petition,
in this case,
in this case.
not in the other case.
Not in the other case, even principal we didn't get. But here we got a portion of the interest.
Where is that document?
At that page, I have made a statement, Lordship, at page 18.
Page 18.
18. One portion we got.
Where is the MOU?
The MOU is at annexure 13, that's,
Page
I just need Lordship.
MOU is at page 94.
94. This one and a part of the interest there only.
এই লাইন কেইটা লিখিছিল ন এইটো কাটি দিব লাগিব ব্ৰেকেটত দি similarly worded বুলি লিখি থৈছে সেইটো কাটি দিব। This court also finds it pertinent to take note of the memorandum of understanding so entered into on 14th of May 2015 between the petitioner herein along with the PHED Department of the Government of Assam. In as much as the contents appears to be different from the contents of the memorandum so entered into by and between the petitioner in WPC number 4631/2023 with that of the PHE department. The contents, the said memorandum being relevant is reproduced herein under page 94. It is also stated in paragraph number 24 of the writ petition that pursuant to the said memorandum,
When was the payments made? I think that's return is interest.
This was made on 33/2000.
an amount of rupees 48,58,246 under the NRD WP plan and only part interest payment of rupees 154,53588 was paid to the petitioner.
And the state plan entirely has not been cleared. Principal amount. 11 lakhs is still pending.
56,170.
Where is that? Speaking out of our.
Speaking on the last submission.
It is also pertinent to take note of the affidavit in opposition filed by the chief engineer PHED department in the contempt case number 517/2018 filed by the petitioner, wherein a statement have been enclosed as regards the dues of the petitioner as on 31st of March 2019 under the NRDWP and 30th of June 2019 under state sector. A perusal of the said statement reveals that the principal amount under the head NRDWP of rupees 58,63,470 was duly paid. However, as regards the state sector, dues of rupees 32, 44, 87 and 9, the same remained unpaid. Additionally, interest at the rate of interest of an amount of rupees 154,53588 have been paid to the petitioner. But there was no interest paid, but there still remained an amount of rupees 225,24,232
Yes.
as regards the balance interest to be paid.
And the state head, everything is not clear despite your lordship's order. 11 lakhs under the state head, despite your lordship's order, everything has not been cleared. A balance of 11 lakhs and odd principal.
Out of these 32.
Yes, 11 lakhs amounts.
No, that I'll take care of. Before proceeding to the next writ petition, it is, however, very pertinent to observe that the interim order dated 27/4/2023, those states that there was no interest payable on account of the memorandum of understanding entered into on 14/5/2019, as well as the registration of the petitioner as an MSME was not known. Could not be asserted. But then also, the respondent authorities have made payment of interest and further disclosed further payment of interest is there is this balance of further interest payable. It prima facie, it therefore appears that the respondent authority, while passing the order dated 27/4/2023, did not take into account the said aspects. While passing the said order. Now, next, WPC number 59666/2000. The facts in the instant writ petition is also similar to the facts involved in the other two writ petitions, wherein also by an order dated 27/4/2023, the PHE department by a speaking order acknowledged that an amount of rupees 24,53,013 was payable by the PHE department to under the state sector to the petitioner. and further rejected the payment of additional interest on account of the memorandum of understanding dated 14/5/2019, and also that, and also it could not be ascertained as to whether the petitioner was in possession of a valid MSME registration certificate as required under the MSME Act 2006 at the time when the work was awarded and executed by it. And it could not also be ascertained if the petitioner had duly disclosed its status as an MSME entity while the said work was allotted to the petitioner. In the instant case, it would be relevant to take note of that the petitioner, which is a proprietorship firm, petitioner number 1, which is a proprietorship firm, was also registered under the Assam Preferential Stores Purchase Act 1989 and was issued a registration certificate on 19/12/2008 bearing registration number DICC/K bracket Roman 4 5130/APSP/2008. The petitioner also was registered under the Act of 2006 and was issued a certificate of, and was also issued the Entrepreneur Memorandum Part 2 on 12/11/2008. Acknowledging that the petitioner had commenced activity on from 6/7/2002 in respect to PVC pipe and on 4/11/2004 in respect to ACP pipe. In the Udyog Aadhaar Memorandum, it is duly reflected, which is Annexure 5 to the writ petition. It is duly reflected that the petitioner's previous registration was on what is the date? Have also mentioned the previous registration details of the petitioner bearing Entrepreneur Memorandum Number Part 2 18/24/12 00988. which is in tune with the entrepreneur memorandum part 2. Enclosed as annexure 3 to the resolution. Where's the memorandum? Annexure 3, page 43. Huh? Annexure 3, page 43.
Page 43.
43. No, that I've seen. I'm not on that. That memorandum of understanding. Oh.
Refer 11. Refer 11. Refer 11 page 82. Hmm? Page 82. And use the page 92 yellow. 92.
The memorandum of understanding which was entered into by and between the petitioner and the PhD. Being relevant is reproduced hereunder, page 90. Huh? In terms with the said memorandum, it was agreed to that the final principal amount under the NRD WP head, which covers ONM head 2, was rupees 1,42,124.1 crore 42 lakh 100. This 00 is missing, na?
Yes, ma'am. But here they have written 1,42 lakh.
Something is wrong. 1,42 lakhs 124 and 37 paisa. It was also mentioned that it was agreed to pay the entire principal amount of 1,42 lakhs and 124.37 paisa due under the head NRDWP by a one-time payment. And there shall be no claim for interest under the head NRDWP beyond 31/3/2019. This has nothing to do with the state.
No, this is only the central.
It is, however, very pertinent to observe that the said memorandum of understanding, as above quoted, do not mention anything as regards the state share payable as well as the interest accrued thereupon. And where is the admission where they are saying how much? Some affidavit they must have said.
Lordship, at page 136. 136,
Huh?
page 136,
Eight,
130,
190,
130. 136. 90,
190.
190 also is there, see it, 190.
It is also apposite hearing to observe that in an affidavit filed by the chief engineer, in the additional affidavit filed by the chief engineer, public health engineering department, being contempt case C number 103/2019. The payment payable to the petitioner. The statement of the payment payable to the petitioner have been duly mentioned. In connection with the contempt case C number 103/2019, which was initiated by the petitioner. From the said statement, it is seen that on the head of NRDWP, an amount of rupees 142,31,062 was payable. And the same was duly paid. On the head of account towards the said sector oblique fund, the amount payable was rupees 24,53,013, which remained unpaid. And interest as on 30th of November 2020 was rupees 788,87,069. In the backdrop of the above facts, statement, the pleadings of the petitioner, let this court now take note of the stand of the respondents in their affidavit in oppositions. At paragraph 7 of the affidavit in opposition filed by the respondent number, by the respondent numbers 1, 3, 4, and 5, to the Special Secretary to the Government of Assam PWD Department, Public Health Department, it was mentioned that the claim of the petitioner for interest was rejected entirely on the ground that their status as MSME was doubtful, and also in view of the memorandum of understanding they had executed with the government of Assam through the Public Health Engineering Department on 14/5/2019, whereby they agreed not to claim any interest beyond 31/3/2019. However, the outstanding principal dues of the petitioners were directed to be paid immediately on receipt of the funds. It was further mentioned that for payment of interest as contemplated under the Act of 2006, a facilitation counsel is provided under Section 18 thereof to resolve any dispute. And as such, it was also mentioned that although the interests have been duly stipulated under Section 16 of the Act of 2006, but any dispute regarding payment must be resolved either by conciliation or by arbitration. The stand so made, submitted, the stand of the respondents PHED, the Public Health and Engineering Department, appears to be same in the other two petitions also, taking into account that the tenure of the order, impugned order dated 27/4/2023, appears to be same. And as such, for the sake of brevity, this court is not further entering into reiterating the stand of the respondents in the other two petitions. It is also seen that the petitioners, it is also seen that the respondents, the petitioners have also filed affidavit in reply in all the petitions, reiterating and reaffirming the stand made in the petition. It was also mentioned in the said affidavit in replies so submitted by the petitioner that the calculation of interest was not done by the petitioner, but rather the interest calculation was done by the respondent. Where is the, in the first petition, the memorandum?
First one.
Page 109. Page 109.
And the second,
The second page 92.
Page 92.
No, in the second, in the second, it's 94.
94.
third,
Third, it's page 92.
92. Okay.
it was also stated in the affidavit in reply that the question of the respondent authorities raising doubts as regards the petitioner being registered under the Act of 2006 does not arise in as much as in the memorandums of understandings which were entered into, the respondent authorities have duly admitted that the petitioners were registered under the Micro, Small and Medium Enterprise Development Act 2006. On the question of application of Section 18 of the Act of 2006, it was stated that applicability of Section 18 of the Act of 2006 would have been there if there was a dispute regarding the amount due. It was further mentioned that the Public Health Engineering Department had from time to time again admitted the outstanding dues of the petitioner, and the same being not a matter in dispute. The question of applying Section 18 thereby to non-suit the petitioner did not arise. In addition to that, the petitioners have also referred to annexure 30 to the various annexures of the writ petition, wherein the Director MSME Institute and the Commissioner Department of Industries and Commerce have written letters to the PHE department asking them to release the outstanding dues to the petitioner. Next. Orders passed by this court. Heading. Upon filing the writ petitions challenging the speaking order dated 27/4/2023, rejecting the claim of the petitioners for payment of interest, this court issued notices to the respondents Same order, na? Same date, different dates.
All came together all the time.
Motion,
No. Motion was different.
different dates.
No difference. In the motion dates?
For girl, it's 14.
Right. Guard, first one is 14/8/2022. 23, sorry.
Huh?
14/8/2023, notice.
In
to-
all the three.
No.
No, in first one is 14/8,
The second one is 13/9,
second one is 13/9. And the third one should be
9/10.
9/10.
We should notice. those two. It is very pertinent to observe that though in the order stated, Sub-para koribo, ha? Next para. Hey, heading on. Though in the impugned order stated 27/4/2023, which have been assailed in the three petitions, the respondent authorities duly admitted certain amounts to be payable to the petitioner. But no payments then also was paid. When the matter was taken up by this court on 26/9/2024, in fact, it was submitted by the Standing Council of the PHE department that the finance department's concurrence was pending in respect to the payment of the said amounts. The record reveals that when the payment was made,
After your lordship's order,
huh?
after your lordship passed the order.
Yeah.
Lordship had sometime this year. Sometime this year after your lordship passed. It was the last one. What I've been asking you about the time.
This, the last order was in November 2024 after.
After November 20. No, this year lordship it was paid after lordship's order. You have written something there, there's a slip of paper. They given to you papers, Danny, they given to you papers when they paid. Last one is going, no?
the record further reveals that pursuant to various orders being passed by this court from time to time,
There was a slip of paper which they gave.
payments were made to the petitioner of the dues admitted in the impugned orders dated 27/4/2023 assailed in the three petitions. You have the dates?
I have the caliber is a fact.
have seen this document. This is
25.
here.
January,
It
January.
is
20.
here, but I'm not finding it.
Malike দিছে।
In respect to the petitioner in WPC number 5163, or 4163 oblique 2023. The petitioner was paid the amount of rupees 627645 in the month of February 2025.
Yes.
In respect to the petitioner in number 2, SRK. 7873 oblique 2000, no, wait, number 2, 5273 oblique 2023. The petitioner was paid the amount of rupees 32,64,154 in the month of January 2025. In the case of the petitioner in WPC number 5966 oblique 2023, the petitioner was paid the amount of rupees 24,53,013
Doesn't tell you. Answer.
in the month of January 2025. This court further finds it also relevant to take note of that various adjournments were taken on the ground that the respondent authorities were trying to settle the matter out of the court. However, after giving various adjournments, when it was seen that nothing substantial had happened in the negotiations between the petitioner and the respondents, this court took up the matter on 9/9/2025 for hearing. On 9/9/2025, while hearing the matter, and further taking into account that the stand taken by the respondents to support the impugn order dated 27/4/2023, to be prima facie misconceived, and the interest which has accrued in the meantime had become substantial. This court requested both the parties, if by way of some sort of negotiation, the interest amount would be reduced. Mrs. M. Hazarika, the learned senior counsel, upon instructions submitted before this court on 9/9/2025, that the petitioners were not adverse to having a negotiation in the interest of the state. I'm going to write what Mr. D. Gogoi said. I'm going to put it out in my right. How you have tried to hoodwink this court. Mr. Haibo Thakur, who was the standing counsel appearing on behalf of the PHE department, also submitted that he would advise his client in that regard. Considering the above, this court therefore passed an order on 9/9/2025 thereby fixing 15/9/2025 at 2 p.m. for the representatives of the petitioner to approach the Special Secretary PHED for negotiation. Paragraph 2 to paragraph 9 of the said order dated 9/9/2025 being relevant is reproduced herein under. On 19/9/2025, when the matter was listed, it was informed to this court by the standing counsel of the PHE department, this time by one Mr. D. Gogoi, that there has been certain deliberations going on between the petitioners in the batch of petitions with the chief secretary of the PHED, and there was a likelihood that the matter can be amicably resolved. Taking into account the above, this court therefore fixed the matter on 15/10/2025. On 15/10/2025, when the matter was listed, the standing counsel of the PHED, namely Mr. I. Bottaku, submitted that some form of negotiated settlement had been arrived at, on the basis of which the PHE department is taking steps. He therefore seeks a week's time for the purpose of providing the details as to how much amount the PHE department would be paying to the petitioners in the three petitions. Under such circumstances, this court fixed the matter on 30/10/2025 for further hearing. On 30/10/2025, the PHE department, this time on 30/10/2025, Mr. D. Gogoi, the standing counsel of the PHE department, appeared and submitted that there was no there was no negotiated settlement which had been arrived at. Rather, a communication was issued by the chief engineer PHED to the secretary to the government of Assam Public Health Engineering Department, wherein certain claims of the petitioners were forwarded. Under such circumstances, as there was no negotiated settlement as have been submitted by the standing council of the PHE department. Therefore, by an order dated 30/10/2025 fixed the present batch of writ petitions today for hearing. First, let me come back for the remaining. We'll give it at 3:30.
Three
I have
thirty,
many more matters. Huh?
at 3:30, Lordships.
Yes.
Wait, to the lordships.
Hmm.
My lord, the petitioners before lordships are, my lord, upper divisional clerks, my lord, who were, my lord, initially appointed by the owner.
Volume to boy.
Am I audible, my lord? Who were, my lord, upper divisional clerks who were initially appointed in terms of a, my lord, central recruitment done by the Guwahati High Court on the administrative side, my lord. Now, my lord, because of subsequent developments,
Mr. Pangi, you see from your mic, there's some problem with your volume.
may I, my lord?
Yes.
My lord, petitioners, my lord, are upper division clerks.
Hmm.
My lord, serving under the, my lord, subordinate judiciary, my lord, in the state of Arunachal Pradesh. Now, this, my lord, UDCs, my lord, they were initially appointed in terms of an advertisement, my lord, was centrally done by the Honorable Guwahati High Court on the administrative
The
side.
petitioners were appointed as per some central recruitment appointment.
Done by the Guwahati High Court, my lord.
Okay.
Now, because of subsequent developments, my lord, because of creation of post, and on just on the basis of someone being posted somewhere, my lord, one of my junior has now been promoted to the post of solicitor without considering our case. That in a nutshell is our grievance, my lord.
So the junior has been given more promotion.
Yes, yes,
Who?
that is, my lord, that was only on the
Respondent
basis
number
of, my lord,
11.
respondent number 11. That is only on the basis of mere, my lord, chance of being posted at a particular place. And because of subsequent developments. The grievance, my lord, we are raising is at least this batch of candidates, my lord, who were
Let us
centrally
see the
appointed.
impugned order.
Yes, at page
Page
111, my lord. Annexure 17, my lord. Yes, my lord. As per the recommendation of DPC held on successors, please to promote the following. We are considered serial number 1, my lord. She was placed in the merit at serial number 8. All
Where
the
is the select
petitioners are.
list? Where is the select list?
Your lord, just a moment, my lord.
Huh?
At page 67, 64.
67.
64, man. 64, man. Sorry, 64. My lord will sign serial number 1 is Shekhar Bas. That is the petitioner number 1. Serial number 3 is Sudeep Biswas, the petitioner number 3. These 3, my lord, came in the general category, my lord, being toppers. And my lord will see the
So
Respondent
number
number is not-
6, list
lord.
of select against reserve quota
Yes,
is the respond number 11.
yes, at serial number 6. Now she has superseded that serial number 3 and 4 also, who are petitioners here.
3 and 4.
3 and 4 also.
Why?
That is because, my lord, will kindly have page 67, my lord.
No, page 67, what has happened?
This is the posting order, my lord.
Final result of the demand of the UDC for the subordinate of the demand, the High Court
Yeah.
has been to allocate the selected candidates in
And the place of allocation.
establishments.
The first 6 in
For
this
what
merit
post? Page 64 is what post?
UDC, my lord.
For appointment as UDC.
Yes,
This was done in the year 2015.
15, my lord.
And then in 2016, it was issued
Yes.
whereby
They were-
the respondent number 11 is at serial number 8.
8, my lord.
And the petitioners?
Petitioners are all at, my lord, 1, 3, 5 and 6. They were placed at UPIA,
1, 3,
5 and
5,
6.
and 6. And
Yes.
he respond number 8.
8, serial number 8. So she
Then-
was placed at Bomdila, my lord.
Okay, then
Then, my lord, in the meantime, new
so
post were
all have been
created.
appointed as UDC.
Yes, my lord.
Okay, then
My lord, will kindly see all the serial number 1 to 6. They were, my lord, posted at UPIA, my lord.
1 to 6 have been posted at UPA all.
Yes.
Oh, yes, all are posted at UPA.
And my lord, the respondent number 8
No, no,
was.
place of allocation is different,
Yes,
but the appointing authority under the rules will be the district and session judge UPA.
yes.
And for 8 is also UPA.
No, my lord, subsequently, my lord, she was placed, initially it was UPIA, subsequently there was creation of post. The additional and district sessions court was
Page number?
upgraded to, just a moment, my lord. What's the page number? Upgraded.
So these creation of different posts have been created.
Yes, yes, my
So
lord,
the person who is in Bomdila,
yes,
this new has been created in 2018.
yes, my lord.
Okay, then
Then, my lord, because of that, our cases has not been considered. My lord, this fact was, in fact, was the Honorable High Court was mindful of that fact. And if your lordship may kindly have page. Page 99, my lord, for a moment.
huh?
Page 99.
Yes.
Close.
Verification against so and so. In pursuance to the letter dated Iman, I'm directed in after considering the various aspects regarding the recruitment of new personnel Iman.
So serial number 1A, my lord. While initiating the recruitment process for filling up of promotional vacancies in their establishment, they can consider the candidature of all eligible candidates, employees working in different district court establishment of Arunachal Pradesh, provided an administration is issued for that purpose and applications are received from eligible candidates. So this was clarified. Despite that, my lord, our cases were not
And
considered.
you are concerned with which which is the impugned letter?
That is 111, my lord.
As per recommendation of the departmental held on Iman, the undersigned is pleased to promote the following subordinate staff from the present post to the next promotional post as per so and so.
Yes.
Now he has been promoted as Seristadar.
Yes, my lord.
Now what is Seristadar's promotional area? It is merit cum seniority or seniority cum merit?
Just a moment, my lord. My lord may have the recruitment rule, my lord.
As per rules?
Page 56, my lord.
Seristadar must have put in years of service so and so by
Yes.
promotion from Iman on quota rota basis.
Yes, ma'am.
What is quota rota basis?
My lord, because the Peskars are also eligible, my lord.
Huh?
Peskars are also eligible.
What is the rota business?
Yes, 61, page 61, my lord.
Understood, but what is this rota basis, quota rota basis?
Because, my lord, feeder post is UDC as well as Peskars, my lord. That is why.
Let's see the promotional, how it is being made. List of
Page 61, my
candidate,
lord.
procedure for appointment, recruitment, disqualification, age, direct recruitment, eligibility for interview. For purpose interview, list of year, appointment year, duration of operation, completion of suitability of certificate, age, joining, and promotion. Assigned by direct recruitment shall be on probation and so and so. Promotion. All officers appointed in accordance with the rules of recruitment on regular basis will be senior persons employed by person.
If your lordship sees proviso to rule 5, my lord.
Then one officer promoted the castle at the same time in the state of the person.
Page 56, man.
Promotion is where? Which
Your
is
lordship,
the provision for promotion in as per these rules?
my lord will kindly have page 56, my lord. Procedure of
Yeah.
appointment. Then your lordship will kindly have the proviso, my lord.
Rule
5.
Rule 5. Subject
Proviso,
to
my lord.
provisions of the recruitment to any category of post in the services shall be made by the in case of recruitment by direct recruiter after giving an adequate publicity. In case of recruitment before the selection by the selected on the basis of seniority. It is seniority cum merit.
Seniority come,
It is the seniority subject to fitness of
Yes.
the candidate to discharge the duties of
Yes.
the post from amongst the persons eligible for promotion.
Yes.
So, and now we have to also come to Rule 22.
My lord, this rule, as per this rule, I understand, my lord.
No. See, you have to also see one thing.
My lord.
The select list which was published, where is that page 54? Page 67.
67.
Recruitment to the so-and-so and the High Court has been pleased to allocate the selected. This is the allocation. The
is the allocation.
select list is this one.
64.
Page 64.
My lord.
Now, you see, kindly come to Rule 22.
My lord.
By direct recruitment or shall be determined according to the dates on which they report to duty.
Yes.
When did you report for duty? When more than one official is promoted to a cadre at the same time, the interstate
Yes.
shall be as per determined if the promotion is made from in one cadre by interstate, if the promotions are made from more than one cadre, same cadre by the period. More than one person is recruited by direct recruitment to a cadre in the interstate, seniority of the person so recruited shall be the order in which their names are arranged in the select list. That is 22(5).
Yes. Yes, 22(5).
So you come under, this is a direct recruitment, na?
Yes, direct recruitment.
Page 64 is a direct recruitment.
Yes, my lord.
So you have to be senior.
Admittedly, my lord.
Okay. Now, Mr. Mukpatin, the thing is that why you have chosen the respondent number 11?
Yes.
That my lord, is because in the meantime, my lord, after the coming into force of these rules, after the recruitment process was initiated, my lord, the subordinate service rules were, my lord, enacted. Now, in terms of that, the district judge is the appointed and the promotion authority, I admit to that. But here is a case, my lord, where the appointments were made by the Honorable High Court. Select list was prepared by them. Our allocation was done by the High Court. At least for these batches of candidates, my lord, there should have been some relaxation. That is my case, my lord. And the High Court was
These
mindful
rules
of that.
came when? On
Rules came in
21st of February.
Yes, 2015.
And these people were, the select list was published.
Thereafter,
In advertisement was prior to that.
prior to that,
So then what was the rule at that point of time?
there was no rules, my lord.
Huh?
There were no rules.
There was no rules. Now the High Court have also not filed any affidavit.
No affidavit.
Okay. So we direct the Registrar General to be present in court. You have made the Registrar General a party, na?
Just a moment, my lord.
Chalo. I think this is the only way how you can get it. Now,
Yes, there should be
respondent number
the party.
11, who is appearing,
My lord, I am explaining for.
they have filed some affidavit.
Yes, yes, they are filed.
What is the stand taken there?
My lord, the stand is, though the recruitment was conducted centralized. My lord, the stand is, though the recruitment was a centralized recruitment, but the recruitment was undertaken under the recruitment rules of 2013. That is the Arunachal Pradesh District Courts Service Rules. Under the District Court Service Rules, the appointing authority is the district judge. And the procedure for preparation of seniority list is provided under sub-rule 6 of Rule 22. My lord, may I read sub-rule 6 of Rule
No,
22?
but the process was initiated
Yes, ma'am.
prior to the rules coming into force.
Yes, madam.
So therefore, the rules came into force only on 21st of February 2014.
Yes, madam.
But the interview as well as the written test was held on 18/7/2013.
No, my lord, the
Are you saying that this particular document is wrong? Page 64 of the writ petition. Pursuant to the advertisement dated 18/7, the written test and interview was held in 2015. Understood? But was it mentioned by way of any corrigendum later on that the
No, no.
rules of 2013 would be followed?
No, madam.
No.
The advertisement was issued where?
18/7/2013. Annexure 1.
1, 55.
18/7/2013. The candidate should be a graduate in so and so, so and so, so and so. So here there was no corrigendum issued.
No, my lord.
Then the rules came in the year 2014.
My lord.
Now, the selection process, proceedings which was taken out there, did it say that they were going to follow the mandate? What is the mandate in which it is to be followed?
No, madam.
Now, tell me, if you were appointed when?
I was appointed, my lord.
ये ना बोलिए ना. ये ले.
You were selected. Now, what do you say about 22/5? Where more than one person is recruited by direct recruitment to a cadre in the interstate seniority of the person so recruited shall be in the order in which their names arise in the select list.
No.
If you are saying that the rules of 2014 is to apply,
No.
then what do you say about 22/5? Read with page 64.
No, but the interstate seniority list under the rules is prepared by the appointing authority, madam. The appointing authority is the district judge, madam. In my humble understanding, my lord, sub-rule 3 of Rule 3 read with sub-rule 6 of Rule 22. There cannot be a interstate seniority list of persons appointed even if through a centralized recruitment process, madam. The interstate seniority list will be district-wise seniority list, madam. This has been clarified by the Honorable High Court in a clarification letter dated 3rd of March 2024, madam. That is part of my affidavit in opposition, madam.
23rd of
March 2024, madam.
where?
Page number 143 of my affidavit in opposition, madam.
Page 140, 142. Or 3rd of March.
Yes, madam. This letter is subsequent to
With
the
reference to
clarification.
the representation, I am directed to inform you that taking into consideration the provisions of 22(6) read with so and so of the Iman, the Guwahati High Court is of the view that a recruitment by way of promotion should be district-wide and as such promotion should be made on the basis of district-wise seniority list, and staff in other districts may not be required to be considered. However, in exceptional circumstances, with the permission of the High Court, any request for considering so and so. So therefore, as per the High Court,
My lord.
My lord, in terms of the rules, even the direct recruitments are supposed to be done by the district judges. Now, here is a case that was not done. The recruitment was not
appointing
done in terms of the
authority said for
2013
the
rules.
post of category of Iman and such other category of the post as the High Court may specify be the High Court. And other categories of post in other places, the district and session judge of ER. Okay. Now, Mr., are you challenging this particular communication?
No, my lord, they have not.
No, my lord, I was not aware of that, my lord.
So why you are not challenging it? Without a challenge to this document, wouldn't it
But
be
what-
difficult on your part?
What I am saying is, my lord, the recruitment was in terms of the recruitment rules that are enforced now. Even the direct recruitment has to be done by the district judge. He is the appointing authority, as the selecting authority also. But the selection
But
process,
the problem arises out here.
my lord,
Here, what they have done is they have put each district in a different say.
yes, now, my lord,
As per this communication dated 3/3/2022.
my lord.
But the services, how will be the direct recruitment done in respect of each post of the service specified in column 2 of C? The method of recruitment and minimum so and so shall be specified in Iman. Subject to the provisions of this rule, recruitment to any category of post in the service shall be made by the selecting authority. Now, who
Yes,
is the
ma'am.
selecting authority?
My lord, the district judge.
Huh? How do you
That's
say?
why UDC is concerned, this is a district judge.
My lord, the selecting authority comprises of
In case
district.
of recruitment by promotion, the selection by the selecting authority on the basis of Iman. If the selection is by the selecting authority is to be the district judge, then the centralized selection made by the High Court is wrong. So all of your
That-
appointment goes for a 6. Now, obviously, all of your appointment has to go.
That is what I was saying, my lord. This recruitment, direct recruitment was not done in terms of the 2013 rules. It was initiated way before the rules came into force. That is why I am saying this rule should not apply.
No,
my lord.
where does it say that the purpose of for the purpose of promotion?
Yes,
For the purpose of promotion, there shall be a promotion only as vis-a-vis so and so. Now, kindly come to the impugned document.
my lord.
This is done by the district judge.
Yes, my lord.
Okay. Now you are aggrieved by the fact that the respondent number 11 now has become a Seristadar,
Yes,
whereas they are junior to you at the time of selection.
yes,
But
yes,
if you see that particular document, which is 3rd of March 2022,
my lord,
although the rules does not say so,
my lord.
that the selecting authority will be anything that it will be against each district. It does not say so. Does it say so? Unlike some of the rules out here in Guwahati, that just for example, the 87 rules of the district and session judges establishment in Guwahati is given to everybody. Whereas the chief judicial magistrate rules only confine it within its establishment.
My lord.
Oh no, it's the other way around. So therefore, if it is done within the ambit of the district and session judge coming, West coming,
My lord.
and you cannot participate. Your name was never called for.
Yes, my lord. That
Did
is
you
why I before
participate?
mentioned.
Did they issue a publication? No.
No, no.
So you did not participate.
Yes, my
How
lord.
can you challenge this?
My lord, what I am saying is, my lord, since the initial appointment was done by the Honorable High Court centrally, my lord, and not
So
in terms of-
therefore, Mr. Panging, without a challenge to the
in that-
communication dated 3/3/2022, which categorically divides or say segregates each district establishment separately and the appointment to be made separately, how are you successful in challenging the order of 21/2/2022? That's
Lord,
my question.
Yes, I have understood, my lord. In that case, my lord will grant me some time, my lord. I will
Let
either
me
amend or my
dismiss your
lord.
petition right away on that basis.
My lord, this has come in the way of an affidavit. That is also by the private respondent, my lord. Honorable
No,
High Court has
no,
not-
last time I said that the affidavit has to be filed. If they have not filed the affidavit, the High Court has forgotten to file the affidavit. We are not concerned. But your case is otherwise without a challenge to the document, nothing remains. So you have to challenge this of segregation.
My lord, I will do that, my lord.
So you need to withdraw this writ petition with the liberty to challenge that document.
My lord, can your lordship grant me some time, my lord? I will look into it.
Okay,
And,
half an hour.
no, my lord, another date, my lord.
Huh?
Another date, my lord.
Oh, that doesn't happen with me.
My lord, may I
Huh?
submit some point?
Such things never happens in my court. Half an hour, 45 minutes. We go by minutes, not by days, Mr. Pangi.
My lord, I have understood, my lord.
The fact that I don't go to Itanagar bench does not show that you should be ignorant of my procedure followed here.
I am aware, my lord.
Anyways, we do one thing
My lord,
and we will fix it next week,
my lord.
taking into account. But I will observe this aspect of the matter. You take a
Madam.
call.
My lord, I will take a call.
Yes.
Yes, Mr. Patin, you wanted to say something without an affidavit?
Yes,
Yes.
no doubt. The central recruitment process was done by the High Court, but appointing they have directed to appoint them through district and session judge. Accordingly, they were appointed. Since they were appointed in each district, there is no common seniority list. No common seniority list.
So therefore, Mr. Pating, therefore, the seniority which you are maintaining in respect to the district of West Kamang would have no relation with the seniority maintained in respect to the district of Upia.
Yes, no relation.
So
No.
the petitioners, therefore, the right to promotion. Now, if you see, kindly come to page again 67. Like, for example, the serial number 1, he is appointed at UPIA.
Yes,
Serial number 3, he is also appointed at UPIA.
yes,
Serial number 2 is appointed at 0.
yes,
Serial number 4 is appointed at Daporiju. This is another court. Serial number 5 is appointed at West Kameng, West Siang. Whereas serial number 6 is appointed at East Kameng. These are all different establishments.
No,
So
at that
therefore,
point of-
your stand will be that each establishment will have its own seniority list.
yes.
No, my lord, at that point of time, they are all under the West Sessions Division. There are only 2 divisions.
Understood. But now you are in specific districts.
Yes, some districts.
Now, would it be in the interest of your client now to have it together? The reason
No,
why I'm saying it, why?
I have understood, my lord.
Just for example, at serial number 1 is petitioner number 1.
No, no.
Serial number 3 is petitioner number 2.
Yes,
Serial number 5 is petitioner number 5,
Yes.
4, and petitioner number 4 is serial number 6.
yes, my lord.
If tomorrow you are having an individual if you have a joint seniority list of all the districts together, you would not have a chance to become the Seristadar. Many
my
of
lord.
them.
That I have understood, my lord. But this was a case, my lord, was filed where the junior was promoted. I will take instructions on this also, my lord. Maybe that also is a factor.
So therefore, the petitioner number two's interest may go against the interest of the petitioner number one.
Yes,
Because the petitioner number two also would like to be the senior Seristadar.
yes, yes.
So therefore, everybody
my
will
lord.
have a different. Now, otherwise, as per the stand which is being taken by the Guwahati High Court, each district, just for example, the petitioner number one, who has
Now
been
it- now-
appointed
now-
in UPia, he would become the Seristadar there.
Yes, I understand that. Now it has to be done in that manner only. My only
then
grievance was
we
that
close
the
it.
initial appointment was done centrally, my lord. For that batch of candidates who were appointed, my lord, together, my lord, at least,
So
my
we
lord, some
take
of
the document which had been enclosed as an annexure, as
then I-
the document dated 3/3/2022 as a
My lord.
document issued by the High Court in exercise of 35.
my lord.
I say that it is for every district it will be different. But I think, Mr. Parting, why on earth the High Court is not filing an affidavit? Why the High Court is not filing an affidavit? Why the High Court is shying away of
Now,
taking a stand?
it was a case.
Your
The respondent-
specific stand is that only.
I'll clarify the position. Respondent number 4 and respondent number 5, they were filed their affidavit here, who we have placed it to the registrar for betting purpose. And after that, after filing of that, they never come back. It was the position. And the copy
Well,
of
take
those,
instructions from
Yes,
my
Mr.
friend.
Gautam
Yes,
Bushra.
since it was not vetted, it could not be filed.
We do one thing. We'll ask the Registrar General to be present next day.
And come
Because
to
this is
the,
not how you do it. You Registrar General is the respondent number two. And last time also I made it a very important thing. Mr. T.J. Mohanto was very much here. He has said that he would do something to that effect. He has not done. So therefore, we do one thing because it is the Registrar General who is overall the registrar for all the 4 states, Registrar General. Or is he shying away from his responsibility of not filing an affidavit? He's the respondent number 2. You have taken a stand. The High Court have taken a stand that look here, each district will, because the rules otherwise don't say so. If the rules does not say so, that there will be segregation of in each district there will be a segregation, then under such circumstances, it should otherwise be unified. Like for
And-
example, if you go into the case of the district establishment rules, it is only for each district where the district judge will look into and do it. If you just take the case of a UDC or anybody, or the Seristadar. But if you go for the purpose of the Chief Judicial Magistrate, it will be for many. It will be an advertisement to be issued. Now, what is being done by way of this particular communication, which the counsel for the respondent number 11 has pointed out, is that each district judge shall do it, that means segregate each, meaning thereby it goes against, it is otherwise contrary to the rules. The rules does not say so. So therefore it is for the High Court to come up before this court. What is wrong with the High Court in not doing so? Let's have the Registrar General in the video conferencing at 4:30. I ask him to be present. I don't understand what is wrong with him. Why he has not filed this basic affidavit out here? And as Mr. Mukpartin says, who is the standing counsel of the Guwahati High Court Itanagar bench, he has sent the affidavit for vetting, and it has been last so many months it has been pending. This is a matter of 2022. Does it look nice? help it. Now then tomorrow, if you file that affidavit, the petitioner is also satisfied. Isn't it, Mr. Pangi?
Yes, my lord.
That his seniority will be accordingly taken in UPIA or West Kameng or whatever it may be. His seniority will be taken and then he will fight for his rights there. And it will then become universal because this would become a part of the rules. You are just issuing a notification. Nobody knows anything to that effect. Let everybody know you should. These are more like executive instructions, filling up the loopholes in the rules.
My lord.
Gusto. Laho. Heard Mr. D. Panging, the learned counsel appearing on behalf of the petitioner. Mr. Mukpatin, the learned counsel appears on behalf of learned senior counsel, assisted by so-and-so appears on behalf of the respondent numbers
3 to,
respondent number
3 to 10.
3 to 10.
Yes,
3 to 10.
4 to 10.
4 to 10.
4 to 10.
You appear for 3 also, Itanagar bench.
Yes.
3.
3 to 10.
Right.
None appears on behalf of the respondent number 1 and 2. Pusto. Mr. So-and-so appears on behalf of the respondent number 11. The case of the petitioner is herein where that pursuant to a centralized recruitment carried out by the Guwahati High Court, a select list was prepared whereby the petitioners feature prepared and published by the notification dated 25/8/2015, whereby the petitioners were higher in rank than that of the respondent number 11. Subsequent thereto, the Guwahati High Court had issued another notification dated 6/2/2016, whereby the petitioners as well as the respondent number 11 were posted at various districts. In the various district judicial courts of various district in various establishments in different districts of the state of Arunachal Pradesh. The various court establishments of various districts of the state of Arunachal Pradesh. Subsequent thereto, it is also seen from the notification dated 6/2/2016 that the appointing authority so mentioned in respect to the petitioners as well as the private respondent number 11, where was the district and session judge West Sessions Division, UPIA Papunpara. It is further relevant to take note of that in the meantime, there were various establishment of district courts in the various districts of the state of Arunachal Pradesh. The grievance of the petitioners herein is that although the selection of the petitioners as well as the respondent number 10 were done, 11 were carried out by us centrally by the Guwahati High Court, by the Central Recruitment Cell of the Guwahati High Court. And the select list as well as the notification of, as well as the select list and the notifications as regards posting were also issued by the Guwahati High Court centrally. But in the meantime, the district and session judge, Sessions Division Bumdila, West Temeng district had promoted the respondent number 11 to the post of Seristadar, though the petitioners were otherwise senior in the select list. It is under such circumstances the petitioners have approached this court by filing the writ petition. The official respondents, however, in spite of various opportunities being granted, have not cared to file their affidavit in opposition. It is really astonishing that the Registrar General, who is the respondent number 1 and 2, it is astonishing that the respondent number 1, who is the Guwahati High Court, represented by the Registrar General, as well as the respondent number 2, who is the Registrar General, have not cared to put in appearance. Mr. Mukherjee, the learned senior counsel, assisted by so-and-so, represents the respondent numbers 3 to 10. And further submits that the affidavit was prepared and had been sent for vetting, but till date, the vetted affidavit have not come for the purpose of filing the writ petition, for filing before this court. So, be that as it may, an affidavit has been filed by the respondent number 11, wherein, amongst others, a notification, a communication issued by the Register Administration IC Centralized Recruitment have been enclosed, dated 3/3/2020 has been enclosed, wherein it was mentioned that taking into provisions of Rule 22(6) read with Rule 3(3) of the Arunachal Pradesh State District Court Service Rules 2013, it was the view of the Guwahati High Court that the recruitment by way of promotion should be district-wise. And as such, promotion should be made on the basis of district-wise seniority list, and the staff in other districts may not be required to be considered. It was also mentioned that in exceptional circumstances, with the permission of the High Court, any request for considering candidates from other districts, judicial districts may be considered as and when the situation arises. It is the opinion of this court, it is the prima facie opinion of this court that the rules of 2013 do not emphasize specifically that the promotion should be district-wise, as well as the district-wise seniority list should be considered for the purpose of promotion. Under such circumstances, if the Guwahati High Court was of the opinion that there was a requirement for issuance of necessary notification for filling up the gaps in exercise of powers under Article 235 of the Constitution, there was a requirement of bringing on record their stand, which unfortunately the Guwahati High Court have failed to do. Considering the above, this court fixes this matter again on 13th of November 2025 at 2 p.m. Either the respondent number 1 and 2 shall bring on record their stand by filing the affidavit, or the Registrar General shall be present in the court through the video conferencing link to be provided by Mr. G. Boishwar, the learned standing counsel of the Guwahati High Court, who was present during when the instant proceedings were taken up. It shall also be open. Mr. D. Panging shall also obtain instructions as to whether the petitioners here would like to further continue with the challenge, taking into account the communication dated 3/3/2022.
Obliged, man. Obliged.
Prima base item 1 for hearing.
You are there in this matter?
What's a Kohima bench? But I'm so sorry, Josh.
Yes, Mr. Advocate General.
In this matter, they have decided on the last date of hearing that substantial portion.
Mr. Advocate General, I was thinking,
Please.
see, unless and until there is any proof that the Christian Medical Hospital had been negligent.
Correct.
The question of imposing upon the Christian Medical Hospital to continue to give the treatment would not be in the interest of justice. However, some time must be given to the petitioners so that they can take the child and get the treatment. They may avail the various schemes available provided by the central government as regards the treatment, even in the Christian Medical Hospital or in your hospitals. This is a prima facie opinion of this court, taking into account that the AIIMS in their report dated 18/4/2022
Clean chit.
did not file any fault in their Christian Medical College treatment and said that that was a proper treatment rightly or wrongly. I'm not going to say comment on that, but they said so. I'm sitting in 2 to 6. So the Christian Medical Hospital's treatment is the proper treatment, and this is the local treatment which needs to be continued.
Correct. That's right.
It was also mentioned that the prognosis of the child is not so good. Whatever may be, so this appears to be the only way out as of now in the present proceedings. And on the last occasion, although the matter was fixed on 23rd of September, it could not be taken up on account of our High Court being closed in view of the demise of a singer. But on the last occasion, when I took up the matter at Kohima bench, there was the records of the child were provided to the Additional Advocate General for getting as to the inputs from the state as to whether the state would be in a position to provide their treatment. Anything on that aspect, Mr. Advocate General?
Primarily, your Lordship has correctly pointed out, the AIMS has set the record right as far as primary allegations are concerned. Now, as far as the state is concerned, we have our limitations as far as the treatment issues are
So
concerned.
therefore, I'm saying that therefore my prime facie opinion
Right.
that for some time the petitioner may be given that for a period, some time may be given for the petitioner to shift. It can't be there like tomorrow I ask them to shift. Some time has to be given. Some cushion has to be given. And thereupon, the petitioner may avail the various schemes provided by the government. Like for example, the Ayushman Bharat, which gives 5 lakhs. There are other schemes also whereby if there is a neurological disorder, there are other schemes also, if I'm not wrong.
Correct.
So these are the various schemes which are available. The petitioner has to avail them. The availability will be in many hospitals which is permissible. It may be either in the Christian Medical Hospital or any other hospital wherein this Ayushman Bharat things are being done. Or otherwise the petitioner has to get resources from itself, from themselves. Because otherwise this will have a precedent which would be dangerous in later times. And hospitals, more particularly the private hospitals, will have a big problem in accepting patients.
That's right. Especially those hospitals which are not charitable hospitals.
Yes.
And
I
sometimes
understand the charitable hospital, not only that, any hospital. Just for example, your state is known for having a lot of hospitals, Kerala.
Correct.
They have got a lot of hospitals and the private hospitals also there. They will also be scared of taking, as if this becomes a precedent. It's a very difficult thing for this court. Means it is difficult, but then also a decision has to be taken on this aspect. And it's really sad that the matter took such a long time for a resolution.
Your Honor,
Yes,
if I
madam,
may,
what do you have to say?
I
Did
just
you get
want to make
anything
it very
in the
clear.
meantime?
Yes.
In the meantime, did you get any opinion?
Your Honor, I just want to clear up one point that the advocate was stating. Just to clarify that AIMS did not find Christian Institute innocent of negligence. That's not the facts at all. The letter is there on record. They simply stated that the current treatment being provided to the baby is the accurate treatment that the baby currently needs. That does not mean that there was no negligence in the previous
Therefore, I'm not going to
treatment.
say that, but there has to be something before this court to say that there is a negligence.
Your Honor, but AIMS did not say that there is none. They only said that the
AIMS did
current
not say
treatment,
that there
as in
is
the
negligence
ventilator
also.
support and so forth.
But AIMS said that the treatment which was given by the Christian
No,
Medical
no,
Hospital
Your Honor,
was,
please let me read it.
was
Please let
proper.
me read the letter again. Because I spoke with the AIMS doctor and the letter is there on record, Your Honor, on record. You can read it once again. They're very clear that the current treatment that's being provided, as in the ventilator, oxygen, so forth, the current treatment is the accurate treatment that the baby needs. AIMS gave no answer as to whether there was any negligence because they were never asked for that. They were simply asked whether the baby, whether it's true what the hospital claimed that the baby's conditions are due to a rare disease, which they concluded that absolutely not, it is not a rare disease. And they concluded that the current treatment was accurate for her current conditions. They never made any statement or any claims whether her current conditions are due to any negligence or not. They never went into any of
No,
that.
so therefore,
They refused
madam,
to go
the
into that.
question is, you have to give us something.
Your
Therefore,
Honor, the facts
while
are
from the
that
last time when we took up the matter, did you come up with any report? You said on the last occasion that you will get it from on your own. You did not want the report or an inquiry to be carried out by a commission to be appointed by this court.
Your
So
Honor,
therefore, did you find out anything in
yes,
the meantime, madam?
that the district forum, the consumer forum, once they have received all the evidence from both parties and so forth, they will pass the order. They will make a board and so forth to investigate all of those allegations from both sides. But the current issue in this court is that, you know, the baby is in a life-threatening condition. Without life support, the baby will die. Now, I understand what the court is saying, that the court, without knowing whether the hospital is the one that committed the negligence, should they go ahead and continue the treatment or not? But the baby's life is at stake. The
Madam,
baby
the
does
question
need
is,
continued treatment.
unless there is any proof of negligence from any quarter,
Your Honor,
how can
if I may,
impose upon
yes.
this Christian Medical Hospital to continue with the treatment?
Your Honor, if I may.
Even, just for example, if there is a case of negligence, at best, it may be a case of whatever may be. If it is a case of negligence, there might be a compensation of anything to that effect. Okay, if there's a case of negligence, you point it out to me, then obviously I'll take it up. But this has to be backed by medical evidence.
Your Honor, the hospital
I will
has
just point
submitted
out
in
at the
writing.
cost of interruption, with your lordship's kind permission.
Sorry, if I can just finish my sentence. The hospital has submitted on record and in person multiple times that the Nagaland Medical Council has come to their investigation conclusion and has cleared them of all negligence. We have requested a copy of that letter multiple times by the hospital. We have also requested in the court to let them provide their own record.
What is
Where
that
is this
document?
letter from AIMS? Nagaland Medical Council. The hospital has claimed that they have been cleared of all negligence by the Nagaland Medical Council. We, the petitioners, submitted a complaint to the Nagaland Medical Council. They had an investigation. We went and met with the members of the medical council, the head members, including the vice president, and I've spoken with the president also, and so forth. We had a 1 hour plus meeting with them, where they went over all of our evidence, interrogated us about every single allegation. And we were told that the vice president confirmed that the director of the hospital, Dr. Sedevi Angami, he is also a member of the medical council, that he was present in the meeting during the investigation. Now, how is that possible? That's complete bias. How can they allow the person that is being accused of negligence to investigate
You're
himself?
digressing from the point.
So my point is, they
means
claim that
that
they
you
are
need to
innocent.
come
They
up
claim
with
that AIMS has.
Some medical evidence to that effect.
Let
where
them
the
provide the
doctors have
letter,
said,
Your Honor.
yes, there was any fault on the part of the Christian Medical Hospital.
Right,
It
Your
can't
Honor,
go
let
on
them
like
put on
this.
record that letter from AIM, from the Nagaland Medical Council. Let them provide it. Let them provide us a copy. Let them put it on record, since they're claiming that that letter has found them innocent. We have requested, even in the district court, they filed a case against us. we've requested, please give us that letter that you claim that you've been found innocent of negligence. Then it's not very hard to just provide the letter to the court. They've not provided the letter to the High Court or to the District Court, yet they keep claiming this. So let them provide it. What is their
Madam, my only anxiety in this matter is not for all the other aspects. Only thing is, should this court further continue with the interim order? Yes, Mr.
Absolutely, Your Honor. If the interim order is dismissed, then the baby's life could be
Yes.
at risk.
Mr. Abraham, tell me, what do you want to say?
My Lordship, I am having only very crisp 3 points only, very short. We are not claiming that we are giving the best treatment in this world. No. What is available, we are giving the treatment, best treatment available in our hospital to our resources, number 1. Number 2, just because the High Court has given orders, we have scrupulously enforced the order till date, more than 4 years. We are protecting the baby. So oral, the respondent, petition number 2, this oral representation that the baby is in danger, etc., is not true. I got direction, I got instruction from the institution that the baby is all right. Whatever the infection is coming, they are controlling it. Point number 3, just because the Honorable High Court has given order, we are obeying in letter and spirit, and as on date, 1,42,82,644 is the arrears the party has to pay. Petitioner number 1 and 2 has to pay. We are standing with all these arrears because we respect the orders of the High Court. Now, the main issue before this court is, my submission is, my Lordship has to give guidance how to clear this huge amount. It is pressing us. Number 2, we are not able to give treatment to similar affected babies and children in
Mr.
and
Abraham,
around.
I understand that.
Please,
I
sir,
understand
please.
that. That aspect I have
Yes,
understood. That's not the question. As regards the liability which is there.
One addition, my lord, one
No,
addition.
no, as regards the liability which has happened on account of the orders being passed by this court, the state and you
Yes,
have to work it out. Mr. Advocate General, kindly look into that aspect. You have to work it out. We need to bring to an end these proceedings. We cannot continue these proceedings any further.
Yes, Lord.
So therefore, I will pass an order
Before that, one submission, my lord.
within a week.
One simple submission. If the petitioner number 2 thinks that it can clear, this bill can be cleared with simple swipe, she can pay the money. She is well to do. She is having properties. She is having a good balance, bank balance in foreign currency. If she thinks she can, with the swipe, she can clear the bill, my lord. Yes, my lord. We understood.
Mr. Abraham, those are against on speculations.
Yes.
These are on speculations. I'm not going to deal with all this.
I leave it to my lordship.
My thing is that you need to hear. I'll give the petitioner some time, and in the meantime, the state will take state and the respondent here shall discuss how the existing liabilities which are there, and I'll give them the petitioner some time.
Obliged, my lord.
Just one submission.
Yes.
Towards the end, she had said that if the interim order is recalled, then there will be definitely serious problem.
Huh?
There will be a serious problem if the interim order is recalled. This is what she said. That itself is a substantial affirmation of the fact, as my learned friend has put it, that whatever good treatment could be provided, they are providing. As I understand from the records, which I've been going through, though it is not, the state is not directly involved in this, I hear that there is a lot of resentment even for some of the staff to look into this case. They are very afraid that complaints would be filed of.
All he said, no evidence of such.
1 minute. Please don't interrupt when I speak. Then we'll ask you to file a proper affidavit on your entire assets. I don't want to take that stand. Therefore, my lord, as far as the current provision is concerned, when we spoke of All India Institute of Medical Science, we must understand this petitioner is not a doctor or a scientist to
Huh?
give
Not
her.
that?
She is not a doctor or a scientist to give us that this is right and that is right and this is right. As
Neither
right-
am I, Mr.
Yes, correct. That is why your lordship, nor am I, none of us are. So therefore, what is the tangible proof we can get? Corroborative evidence. Get the specialist. If you try to bring the specialist, that is not acceptable. First thing I would suggest is let her go to any specialist in this matter, and then let them submit some report, whatever it is, as far as the treatment schedule is concerned. Because that is what she's asking. She cannot say this is not right, that is not. We are not doctors.
No, but Mr. Advocate General, why should I enter into that sphere?
No, I am only saying
If I
this.
enter into that sphere,
I have gone through the complete record which was made available to me. It was, I think, many of these allegations could have been avoided. One was that. And if she's very clear that she wants to go ahead and go to the consumer court to ascertain whether
I have given them the liberty to go ahead. Let them go.
they are at liberty to go. Because that cannot be entertained here at this stage.
Because in the consumer courts, there will be a doctor there
Yeah.
who have a medical expertise out there who can
Everybody
look
is there.
into all these
Everybody
things.
is there.
They can very
So,
well go there. But the
maybe-
fact remains that the continuation of these proceedings
maybe
cannot go on for all eternity, which has happened.
what is
Although I
turning
say that it was when the initial interim order was passed, it was thought that there was nothing to be done with Christian Mission Hospital
Correct,
at that
correct.
point of time because it will be shifted
correct.
out to AIMS and all. Thereafter, the matter took a different tangent and it was going on till I arrested the further digression and
Correct.
brought it within
I
it.
am very much aware of it. The various steps taken by the court to come and see. The basic thing is the child should be given treatment. That's the main issue. Primary issue is that. Now, where is the treatment available? Like we, as a state, our areas are very limited. If they want to avail of that, that's a different question altogether. But they will not
The
have
fact remains,
Yeah.
what treatment which was provided has been mentioned by Mr. Abraham that day the documents were given.
right.
It appears to be there is no rocket science in
Not at
that
all.
treatment which
Not
has been
at all.
provided.
You are just
So therefore, the state can give, provided it meets within the parameters of whatever the funds available. If they avail those Ayushman Bharat and all these things, they can very well get whatever may be. This can happen in that manner.
it can happen in the manner and the way
But I
the
think
matter.
some push, but
We
Mr.
will-
Advocate General, some cushion is required.
We'll
to the
look into
petitioner
it.
also
But
for
if
that
at all,
particular period.
if at all we are embarking on that also, which is also a positive direction given by this court, there must be some assurance. This day-to-day wrangling on the doctors, if they go to government, that will not be present. That time she may have to give certain undertakings in the event. After I get the confirmation from the concerned hospitals, she's free to go and see whether the treatment would suit her or not. One. If it does not suit her, and if it does not suit the Christian Medical College, either she has to go back to AIMS or go to the proper institutions in Guwahati. We are very impoverished as far as medical facility is concerned. We have just the only state in the country which did not have a medical college till recently. So that by this you can measure what is the difficulty. And I had mentioned to your lordship, even the same referral hospital, it was some grace of the then Chief Justice that we got it. There was opposition even by the specialists not to have it for various commercial interests. So it is a ongoing good hospital which is going on. Whatever your lordship says, I will also ascertain directly from the government that these are the issues. What can we do for them?
Can I have it tomorrow, next week?
Next week you can have it. What date your lordship?
Do you want to file anything?
No, I will only explain to your lordship. Nothing.
You don't want to file anything? Mr. Advocate General, can you ask your junior,
please,
to give me just a written note of what you say? Because you see, there appears to be some problem with your voice,
please,
so that I can very well put it out there in
I
my
will do it.
order.
I myself will-
Abraham, you can also do so if you want.
I'll-
Madam, you can also do so. Send it to the registry, they will send it to me.
that will do.
Pass the order next week. Chal.
Your Honor,
Yes.
if I may just say one thing, I would like to request the court to please order the hospital to put on record the letter from the Nagaland Medical Council that they have.
You file it under the RTI. Madam,
But Your Honor, they
that,
have
that document,
submitted
if you
in
want,
this
you
High
file it
Court.
under
They
the
have
RTI.
said-
The RTI applies.
I have requested them multiple times, they have refused.
Madam,
Your Honor.
why are you not taking the help of a good pediatrician out there and get your report on the basis of all the documents? Because you see, the first prayer in your writ petition is the records. You have all been provided with the records. On the basis of the records, why don't you get an opinion from the pediatrician?
Your Honor, if the medical council has already come to the conclusion, then should we not get a copy of that letter? And the hospital has said it in
If
writing,
that
on
letter is
affidavit in the
there,
court.
madam, if it is a letter that letter is outside the scope of the writ petition now. Now, if you want that letter, you file an RTI. Ask somebody
Your
to
Honor.
file an RTI and get that letter, madam.
Okay, Your Honor.
We'll
Your
pass
Honor,
the order.
also-
Kindly send your things.
Your Honor, also the communication between the hospital and the state, I have requested copies of it. But
Communication between the hospital and state, that is between them. This has nothing to do with you. That
But
is
I'm a
as
party of
regards
the case.
how
Shouldn't all
that,
parties of the
madam,
case
that is
have-
how, that is as regard how that huge amount which is now due to the hospital will be treated by the state. How they will be dealing with it. How do you help get any benefit on the basis? We are concerned is how to get the benefit, any treatment, the baby can be given that continued treatment. But the only problem, madam, we have to face is, if it is nothing rare or unique, it becomes very difficult. Otherwise, these type of judgments are very difficult to, tomorrow everybody will do it. You saw my earlier judgment in the Binoy Kumar Deka. There
Yes,
was
Your Honor.
a case of 1 in 10 million. This thing has happened. So these are things which have to be taken into consideration. Anyways, I'll look into it. You kindly send it. We'll pass the order. CAV.
Okay, Your Honor.
Here we go.
May I please the lordship? Lordship, pursuant to your lordship order, dated 3/11, I have filed an affidavit, reply affidavit, and for bringing on record, that is not on record, my lord, I can supply a copy.
If it has come,
No, my lord.
I have a copy of it.
Yes, I have extra copy, my lord. In the last order in paragraph 4, your lordship was pleased to ask for, my lord, whether there is any document to show that the PDS item were lifted by the petitioner in different fair price shop. In paragraph 5, I have stated it. Page 97, I have annexed the document. Allegation is that Hormuz Ali has lifted the items after issuance of license in favor of the petitioner, my lord. That is true, but license was issued in the month of September, 2nd weeks. Before that, my lord, he has lifted the items.
And inquiry was conducted for the month of July and August, not September. My appointment as, my lord, fair price of dollar is on September, my lord, 14.
This was done in 2020.
Yes.
Your inspection was carried out in the year 2022.
Two, my lord, my appointment is in 22, my lord.
Understood.
Yes.
But you lifted for the month of October.
No, my lord.
Yes, that is what you are saying. You did not lift for the month of September,
But till
but you
October,
lifted for the month of October.
my lord, I have stated till October, my lord, verification of machineries were not done, my lord.
Understood, but you see, but did you lift? You are not answering to that point. That did you lift for the month of October?
I have stated, my lord, in my affidavit, my lord.
No, you have not.
Yes.
Only see page 93. Read it. Thereafter, the petitioner was informed that the PDS item for the month of September were already lifted dispatched in favor of FP shop of Harmuz Ali in the first week of September 2012.
Yes.
It is further mentioned here that till month of October,
October
necessary.
necessary weight
But the
machine.
question, what I was asking you is different. Did you lift the quantity for the month of October?
No, my lord. That was continued. I approached the authority for allow.
That is not what has been mentioned here.
My lord, that what happened, my lord? The
Mr. Jayame Chaudhary, you have not mentioned that very aspect of the matter here. My specific question, because here it was, what was the allegation? That on 7/11/2022, when the inspection was carried out, it was found that you have allowed the lifted quantity to be sold, disbursed through Harmuz Ali. And this is being also verified on the basis of the statement of the consumers and Harmuz Ali. This is the inspection report.
yes.
Now, therefore, my pointed query is, obviously, in the month of September, you could not, because you issued notice to your fair price shop was only issued on 16/9/2022.
Yes, ma'am.
But what about the month of October?
October, my lord, what happened? I have stated in the last paragraph, my lord, last paragraph. It is further mentioned here that till the month of October, necessary weight machine and stock register were not verified by the authorities for starting operation of the fair price shop as required.
But did you lift for the month of October?
No, my lord. No, my lord.
Where is your statement? to
I have
that
not
effect?
lifted that. My lord, in the inquiry report.
Mr. Jayame Chaudhary, this was the specific issue I have asked.
My lord, in the inquiry report, my lord, lordship kindly see in the inquiry.
Better file an appeal. Go file an appeal. An appeal lies against this.
Yes.
So go there. Take up all these points out there. And these appellate authorities are more kind, I will say, than a court like me.
My lord, in this case, what happened?
There is no.
Inquiry conducted for the month of July and August, admittedly in the reference. For the month of July and August, FIR filed for the month of July and
It would not have been for July and August because in respect of your case, it was specifically mentioned that on 7/11/2022, the inspection was carried out. You don't go on the basis of the top, what was mentioned in your case. There were many inspection reports in respect of many. All there. What do you want to do? What do you want to do?
And he has not stated in his petition that.
These are questions of findings of fact. You have not denied to that aspect.
My lord, so far the inquiry report is concerned, my lord. Inquiry reference was made only for the month of July and August, my lord. Lordship kindly see in the inquiry, my lord.
Hello.
And affidavit.
Okay. We then dismiss it right away here. Nah.
My lord, I'll approach the, my lord, appellate authority then.
Mr. Jayame Chaudhary, heard Mr. Jayame Chaudhary, the learned counsel appearing on behalf of the petitioner, and Ms. Udas, the learned additional senior government advocate appearing on behalf of all the respondents. The petitioner herein have assailed the inquiry report dated 3/12/2022, as well as the order of cancellation of license of the petitioner's fair price shop dated 22/1/2024. Dated 22/12. What is that 22/12?
My lord, dated 22/1/2024, my lord.
22/1/2024.
Yes, page 73.
24. no, 22/1/2024.
Yes.
Issued by the Assistant Director FPD, the NCA, Morigaon. From the inquiry report, it is seen that the respondents that upon inspection being carried out, it was found that the petitioner was not operating his fair price shop, and instead he was supplying the PDS commodity to his consumers through the nearby fair price shop of one Harmuz Ali. It is also seen that this court, by an order dated 3/11/2025, inquired with the learned counsel of the petitioner as to how the petitioner can allow the lifted PDS commodity which was assigned to his shop to be distributed through another fair price shop. In that regard, an affidavit has been filed by the petitioner today. However, the said affidavit does not clearly state as regards the lifting of the PDS commodity in the month of October, and thereby allowing the said PDS quantity being allowed to be distributed through another. From the materials on record, it therefore appears that there are various disputed questions of facts as to whether the petitioner actually lifted the PDS quantity for the month of October, and thereby and permitted the distribution of such PDS quantity through another shop. While taking up the matter, it has been also duly intimated to this court, informed to this court, that an appeal lies against an order of cancellation under clause
29. 29.
and so of the Assam Public
Order 29,
clause
clause 1.
29(1).
Yes.
29(1) of Assam
Public Distribution of Articles Order 1982.
And the petitioner would like to avail such appellate remedy wherein various disputed questions of facts can be dealt with. Taking into account the above, this court therefore closes the instant petition in view of the said submission, thereby permitting the petitioner to file an appeal against the order dated 22/1/2024, which have been impugned in the instant proceedings before the appellate forum. And if such appeal is filed within a period of 30 days from today, the appellate authority shall decide the same on merits without raising the issue of limitation. Writ petition accordingly stands to. Yes, motion gita diyo.
Item 1 fixed at 2 p.m.
Milord, this short
Oh,
point,
that one.
Milord, that fair price shop.
So I will give you a doctrine of election now. Whether you want to do that or wait for your motions, do your motions.
Milord, I'll elect the doctrine of election. Milord.
We'll have it some other day.
Yes, yes.
You have filed this affidavit,
Yes,
not today.
Now, my lord, they have
Affidavit
changed
required.
that, but the private contractor they have removed, and the idea was they have said that they have engaged a cooperative society now.
Yes.
Now that is an interim arrangement. Now, in respect of the NIT, the same thing is to be done. That's been had. In respect of the main NIT, which is under challenge, now they need to adopt that procedure. We challenge the NIT because, my lord, they also gave option to the private contractors. Now, the impute NIT should be confined to only the cooperative societies and other
they- have they
agencies
mentioned
permitted
about
under this statute.
In your affidavit, did you mention it?
No, my lord, this is pursuant to the honorable court order of seventh of the last order, my lord.
Now, are you therefore envisaging in view of the NIT provision
Ah.
to permit private contractors
That,
other than the cooperative society? That is the question.
Or the authorized agency. The expression used in this statute is authorized agency, which includes a cooperative society.
well, this is the affidavit filed by the deputy commissioner, and the deputy commissioner has taken steps pursuant to lordship's order dated 7th of August 25. Well, NIT was issued accordingly, well, private meeting was there, ultimately this is the procedure they have adopted.
Which is the impugned provision of the NIT?
Yes. NIT, my lord, is at page number 43. And the relevant
44.
portion is at page 44.
Invited from Indian handling
Yes.
for Indians interested in handling transport contracts having geographical knowledge of so and so as appointment of so and so for transportation of so and so. So therefore you are calling everybody.
Yes. Now it
Only
comes-
limitation is he has to have geographical knowledge of Tinsukia for selection and appointment.
Ah.
Isn't it? And there might be other criteria. Qualification criteria has minimum 1 year experience of transportation under the NFSA in the last 5 years. The bidder has submits experience certificate from consumer. Bidder is the partnership firm so and so. So what intending? Does it say private? Means, or is it deemed to be private? taken into-
Everybody can participate.
Earlier, my lord, the serial number 3, page 46, my lord, qualification criteria for bidder, Roman 3,
Roman 3.
Roman 3.
Bidder is a proprietor of the partner or director
Yes.
must have annual average so and so during the final. In case of so and so, the turnover limit is not exhaustive, but considering requirement of so and so. Funds for annual transportation work. The tender so and so. Now let us see the act which were.
Yes, yes. We have annex, Miller. Please come to page 62, Miller. First, come to page 62, definition of authorized agency. 2G, somewhere in the middle. Authorized agency means the concerned department of state government or a body corporate or any company owned by it or cooperative society.
And where is the
Concerned
provision?
department of the state government or a body corporate or a company owned by it. That means a government company or a cooperative society.
So it
That-
has to be either a department of the state
Yes, yes.
or it may be a
Body corporate
body corporate or a
owned by it.
company of the state government.
Yes. Now please
Or-
come to,
A cooperative.
yes, please come to page 65, Miller. 7. This is the prescription, lifting of food grains by
If
states
The food grain from the designated depots of the corporation through its.
through its
authorization.
authorization. That is the catch, Miller. Then 11, 711. State government shall devise suitable mechanism for transportation of food grain from corporation godown to intermediate godown and door to a doorstep delivery of the food grains to the fair price shop. Provided that the state government may also transport directly from place so and so, grown it so and so, a doorstep fair price salary. Then Milord will kindly come to next page, 8.3. State government shall ensure through authorized agency physical delivery of food grains to fair price shops by the end of the month preceding the allocation month, and in any case not later than first week of the allocation month. So,
So for you, therefore,
Ah.
a proprietor partner
Ah.
or a director of any other company
Ah.
would not come within the ambit of authorized.
that's the point. And our case, we are cooperative society, we did the job earlier. In between, my lord, the deputy commissioner invited a tender whereby they permitted everybody. So that is our only case. It's not that we are saying it should be given to us.
Well, we responded to the interlocutory application, we filed the affidavit, order was passed, and accordingly that has been complied. But well, the authorized agency as has been well, sought to be well, interpreted by the petitioner. That well, the authorized agency means the according to us, well, because at the time of initiating the tender, that was the direction given to all the district commissioners from the authority that the even whoever is authorized by the government, well, if body corporate is also there. The stand of the government is also necessary. Lordship has seen 16.
No. Or a body corporate or company owned by it.
Well,
You cannot authorize. You have to own it. It has to be your ASIDC.
National Food Security.
but,
You can have the NRL also. NRL has 55%. Nah. Have the NRL also.
no, for the.
They can also do it.
For the
But it has to be a government company.
Tier 1, Tier 2 transportation, well, whoever is having the capability of transporting, they were allowed. Ultimately, it is the distribution of the NFSA rights, you know. But what I would like to submit, but ultimately the situation has been taken care of pursuant to the honorable court order.
No,
No,
that's-
let me have I have already communicated the instruction of the government. Let me have that, I will place it, Lordship may consider that. Otherwise, since if Lordship, in terms of the interim order, Lordship holds that the authorized agency is only this. Ultimately, the decision of the government in allowing that will have a repercussion on that.
No, only worry is why
The situation is taken.
why I am so concerned of an early disposal of the matter, taking into account that an interim arrangement is going on in view of an order being passed by this court.
True.
So these interim arrangements which are going on is not in consonance with Article 14 or anything.
No, this has been done by a NIT.
Whatever may be, again, another
NIT
third party
what?
rights of multiplicity of rights happen and all. We have it, okay, next Tuesday, finish it off. You come up with that and file your affidavit.
But
Giving it as regards what is the, otherwise I'll be, this is 2 minutes job.
that's true, but
Even under the National Food Security Act section.
No, otherwise you don't take the 100 rupees from the government.
no,
Do it.
No, this is different. This is different.
What different? This is under the NFSA. This is another, because
Yes,
of
yes.
that, you are getting the payment. This payment is being reimbursed by the government.
Central government, yes,
Don't
yes,
take that
yes,
money
yes.
Now, under NFSA.
and do whatever you feel like.
The NFSA 75% the central government is paying, 25% for the state government.
No, isn't it the supply under the NFSA?
NFSA.
So if
This
it
is-
is NFSA, you have to follow the mandate of this notification.
Yes, yes.
But
That-
at the end
that
of
has-
the
that
day,
has-
this central government scheme, central government is the, creator. They are specifying something. How can states sit in appeal over it and come up with some ideas, which is contrary to the provisions of the act?
Okay. Good sense may prevail. Come up with an. Next week.
But, thank you.
Otherwise finish.
Give us some more time, Marat.
No.
Look,
Next
this
week.
arrangement is till the for 25-26.
Huh?
This has been done till 25.
No,
How
we have
can
to
it be
set
done?
aside this NIT, na?
No. The present arrangement with.
I think
No,
perhaps one.
unless you issue a corrigendum, we have to set aside the NIT.
That's Lordship may kindly give us.
Only for issuance of a corrigendum I can give,
It's recently organized.
by which you can say that these people are out.
May I clarify one thing, Milad? This arrangement, interim arrangement of running through a cooperative, so it is a very recent thing. Otherwise, the private operator was doing it till the other day, last month.
It was
It's not-
it was a system not only implemented in Pinchuga, it was done.
No,
Now, what is the stage of the NIT?
No,
it was
because
stayed-
it was
it
stayed
was
by
stayed.
this honorable
Now,
court.
understood, means
No,
tender-
they have not processed after the
no,
order.
have the tenders submitted.
My lord, order was passed on 7/4/25. Since then, my lord, it is in standstill.
Possibly not.
And my lord, the earlier contract, a private contractor was engaged by the district authority.
Now bid submission last date is what? Closing date is 23/4.
Yes, and my lord, the stay order was given on 7/4.
Then obviously you can issue a corrigendum.
Mhm.
Issue a corrigendum, make it authorized agency, matter over.
Yeah, that's all, my lord.
I am asking for some time, my lord, for the government's, this time, my lord. Kindly give us 10 days time, my lord. Will Lordship will take it up on 24th?
It's a matter of 2025 early part. We are in the late part of 2025.
That's true.
Yes.
Lord,
Hello, 1 week,
kindly take it up on 24th, my lord.
24th. 24th is too long a date.
Hmm.
We finish it off on 19th, maximum.
May not be on the-
You said 10 days. Keep your word. You said 10 days. We finish it up on 19th at 2 p.m.
Then kindly take it up on 7th or 18th.
Huh?
7th, 17th, my lord.
No,
17th.
19th.
Not 18th, 19th, my lord. I have some personal difficulty.
Okay, 9 is 17. Okay,
17.
20.
From 19 till 2-3 days, my lord. I have some difficulty.
Okay, 18th.
On 17th, my lord, if possible.
I have heard the matter at length. Full stop. The issue involved in the present petition is as to whether the notice inviting tender dated 26/3/2025, thereby permitting a proprietor, oblique partner, or a director to participate in a tender process for handling and transportation of food grains under the National Food Security Act 2013 is permissible in view of section 2, section or what, rule?
My lord,
No,
it's an order, my lord.
Clause 2G of the Targeted Public Distribution System bracket Control Order 2015. Read with section 7(1)
And 8(3), my lord.
and 8(3) of the said order. Section 9, clause 7(1) and clause 8(3) of the said order. Full stop. This court have also duly taken note of the order passed by this court on where that order by which
7/4, my lord.
7, no.
The I.
Thereby stopping all these people from doing all these things.
7/4/25.
So taken note of. No, this is only stay by which the private contractor was removed.
There is no order, my lord.
Huh?
There is no order about removing.
Then how did they? Why
No,
did
what,
they?
because of the stay order, they were operating through some private agencies.
No, then they were removed.
Then subsequently, my lord, because when we brought the matter to the notice of the court, the last month they have said that they have engaged now a cooperative society.
So on their own.
No, there is a IF.
IA was filed.
IA was filed in the IA, Lordship has
This
passed.
court have
IA 1557.
This court have also duly taken note of the order dated 7/8/2025, whereby the learned coordinate bench have duly expressed the opinion seven eight 2025 in IA civil number 1557 of the 2025, whereby the learned single judge, learned coordinate bench have duly expressed the opinion on the issue and thereby directed the ad hoc arrangement made by the Deputy District Commissioner Tinsukia to engage private contractors. First of just vote. Mr. D. Nath, the learned counsel appearing on behalf of the petitioner, the respondents. submits that he needs 10 days time for getting in further instructions in the matter and to file an affidavit on behalf of the state of Assam. Accordingly, list the matter on 21st of November.
From 18 till 21st, I have some difficulty.
Engage somebody else.
On 17th, 17th.
No, not. On 17th of November 2025. At 2 p.m. for further hearing. Full stop. The affidavit be filed on or before 14th of November.
For motion item 16 and 17.
ওপৰত কোনটো আছে?
Mrs. Hazarika, where is the other one? Mr. R.R. Gogoi. Mrs. Hazarika, you, I think, I was thinking while dictating the point. Section 16 says that it will be compound interest with monthly rests. How do you arrive at that particular interest? Because if you see and this is as per 3 times the RBI rate. RBI rate has not been specified. So it may vary from time to time. So have you taken into account that variation?
Yes, we have not done the calculations.
No, forget about them. But have you taken, because you see, just for example, RBI rate today says this amount. So it will be 3 times of that compounded on that aspect.
Yes, sir.
And thereupon it will happen. One thing. And for you, you have a look at it. Your specific stand is, then look here, let them go to the MSME. Now, are you not therefore admitting that they are MSME? You are admitting they are MSME. Now, if you are on your own affidavit saying that you want to go to MSME also, which I have duly recorded in my order, now can you now say that they are not MSME? Can you now challenge the jurisdiction of the MSME? No. In that regard, you look into the judgment of the Supreme Court in 2024, 12 SCC 221. My goodness, and madam, for you, I'll take it up the matter again for further dictation on Tuesday. You have a look at 2024 SCC online, Cal 6617.
Doctor, can it be on Thursday? If it's not convenient.
Next Thursday. Okay, next Thursday for further dictation. 2024 SCC online, Cal 6617. Here, the learned single judge of the Calcutta High Court explains section 16 very nicely, and more particularly how the calculation has to be carried out. So if the calculation has to be carried out in that manner, I think you may have to require that. Then you see another judgment is Gurpreet Singh, because that will also be required, taking into account that they have made the payment in the meantime. So that apportionment in terms of section 60 of the Contract Act, unless the court otherwise permits, the interest will be apportioned. So then your principle remains intact. So the principal interest will keep on accruing. See that judgment in Gurpreet Singh, that is a constitution bench judgment on land acquisition. Have a look at it. We'll take it up on Tuesday.
On
Thursday. Huh? You look into this because of that you cannot say anything on that.
I think Lordship should impose some cost for Thursday.
Why? Anything Thursday is there?
I am always willing to accept any date. Sometimes.
No, I'll finish it up on that day. Because I looked into these two judgments, because you may have to a bit, because I have not recorded your argument. Your arguments has to be tweaked in terms with the Calcutta High Court judgment.
Because all this while, Lordship, we were saying that you calculate, we accept whatever. We even agreed for the mediation, we agreed to it. And they kind of were not willing to take it.
You also look into another judgment of Justice Narasimha on this aspect of the matter, which says that how MSME Act overrides the Arbitration Act,
Yes.
which is being mentioned out there, how it overrides. And there's overreading this, have to take care of that memorandum of agreement also, which has been entered into. So in that memorandum of agreement, in one of the cases, nothing is mentioned about the state share. The others, they say about an interest. Only interest is there, something is said. And in one case, some interest is being paid. But you want more than that. So therefore, you have to say on that aspect that it overrides. There cannot be an estoppel against the state statute.
And they can't enter into MOU against the statute. The MOU is also against the statute.
So therefore, there cannot be an agreement contrary to the statute. Itu Simani Kurimaha next Thursday. We'll have it at 10:30, madam. Again, torture other councils. Yes.
Yes. Malab, there are two petitions. One is 5051, where we assail Milord. We basically apprehended that because of the clause that is 2.2.2.4322, the Railway Authority may not consider our tender. And this Honorable Court was pleased to pass an interim order. 2.2.2.4 at page 99.
Categories and factors for evaluation technical capacity. Page 98.
Page 99.
Okay, which one? There should not be history of collapse of superstructure,
substructure of any span of a bridge, flyover, viaduct, metro rail link, work during construction service in the last 3 years, ending last day of the month of the previous to the one in which tender is invited. Undertaking in this regard shall be submitted along with it. So we apprehended Milord because there was an instance in Patna. Therefore, they might disqualify us. So, my lord, we moved this honorable court, and this honorable court was pleased to pass an interim order, which your lordships will get on 8-9. Sorry, 1-9, my lord. 1-9-25
What does
order.
the Patna High Court say?
Yes. If your lordships would kindly come to that order, my lord. 1-9. After issue notice returnable on 8-9-25. Now this first subpara, considering that petitioner has already submitted the bids, which is scheduled to be opened on 2-9-25, and also considering that challenge to terms of disqualification would require a detailed deliberation which should be taken up on the next returnable date. In the interim, it is provided that respondents shall consider the bid of the petitioner subject to further order of this court. So thereafter, my lord, the matter was listed on 9th, where, 8-9, where the, my lord, my learned friend appeared, he made a statement, my lord. By placing communication issued by NF Railway dated 8-9-25, Sri So-and-so learned CGSC submits that the scrutiny of the bid, including petitioner's bid, would take considerable time. Therefore, he may be granted time to file a detailed affidavit in opposition. So on that day also, it was indicated that in terms of the interim order, my lord, our bid would be considered. Eventually, my lord,
your apprehension was in this petition is in respect to that much.
Yes, only that much.
So the consideration is only that they would not be considered on the basis of that clause.
Yes.
Nothing more than
Nothing more than that. And my lord, the idea is you consider it, we'll see whether subject to further order of this court. Now, what Railway Authority did, my lord, they considered and rejected our case.
No, they rejected it on a financial.
This ground and on the ground of finance, two grounds. If your lordship takes the other petition, then we can show, my lord. In the other petition, my lord, page 126.
Yes.
This is the, my lord, they uploaded this SPS Construction India Private Limited. Reject remark non-responsive as per 2.2.2.2, that is financial capacity, and 2.2.2.4, that is the other one. Therefore, we filed this petition, my lord. We took permission from your lordship, my lord. Matter was listed on last.
Yeah.
What was the date? Okay. Day first, huh? 31st, then, my lord, we made a prayer that both the matters should be taken up together. That is how the matter is listed. Now, if your lordship kindly takes this petition, my lord, we submitted our bid, my lord, on 22/8/2025. Huh? Or 27/8. My lord, lordship knows the financial statements would be ready by 30th of September. Therefore, we could not have submitted that. Therefore, there is a clause in the tender 2.2.2.72 at page 93. So lordship should kindly come to page 93, my lord.
Which petition?
Second one, my lord. 6274.
But first satisfy me in the first one.
Yes. Now, my lord, before I delve on
Mr.
the
Gogoi, you will get the order today, huh? That one. But that matter, then on Saturday I passed that order. It's a bit longish, so it is getting.
Already I informed them. They will do. It's coming.
Kolia,
They also understand the.
Kolia from the, which is given when prior to the accident or after?
Yes, Mr.
Yes.
No, here I have seen the clause.
Yes.
Clause is there.
Now,
There should
now,
not
now,
be a
now,
history
my
of
lord,
collapse.
now, lord, kindly see the clause. There is there is no clarity on various aspects, my lord. Why that notice aspect is relevant, I will address your lordships on that. I'll rely on some judgment of one judgment, division bench judgment of the Delhi High Court and two Supreme Court judges. Lord, the preponderance of the judicial view seems to be that when it comes to debarring a party from participation in a tender on such ground, there the compliance of the rules of natural justice has been held to be sine qua non, invariably, my lord. Now the question is, now kindly see, my lord, here it is not even indicated. Supposing there is a collapse, there could be a collapse. Collapse could be on account of fault of the contractor. Collapse could be on account of failure, design failure. So nothing is indicated, my lord. And my lord, based on the same thing, the party who has been adjudged as L1 in this case, my lord, he also has similar example, my lord. In fact, earlier, the one at page 99, it was 5 years. The provision at page 99, my lord, that is 2.2.2.4, etc. There the initial period was 5 years. It was reduced to 3 years because why they wanted to help the party L&T who has been now made L1. They also have similar instances, my lord. And most importantly, in the affidavit filed to the railway admits why they have done it. Because they say in case of L&T, there was a change of management, therefore they became wiser.
Huh?
Yes, they file affidavit today. Kindly take their affidavit, my lord. Para 6. The affidavit starts at page 279. If your lordship would kindly come to 281. That with regards to the statement made in paragraph 7 of the writ petition, the answering deponent begs to state that the term meaning of collapse have been clarified in revised RFP 5 years history period is reduced to 3 years based on their various queries. The logic behind this was the management team responsible for such failure of contractor agencies are changing, and also agencies improve the working system over the period. So, my lord, as far as we are concerned, our contract for work in respect of which there is a collapse, it has not been cancelled. We are still continuing with the work. And my lord, our price is substantially lower.
Price has no.
No, I'm just making a statement, my lord, for lordship's kind information. Now they say, now if your lordship would kindly take the other writ petition for a moment, so even the old first petition at page number 228.
But there is a the construction which has been which has fallen in your case. Do you come within the mischief of this rule?
My lord, not exactly, I will say. Because there was some mishap, my lord, that we addressed and we are continuing with the work. There was a PIL in the Patna High Court. PIL is also closed. I have annexed the order.
Huh?
We have annexed the order of the Patna High Court.
What does it say?
Yes. The Patna High Court order, my lord.
Page 200.
At 200, my lord. Please come to page 200. My learned friend would like me to read perhaps paragraph 2. Now the agency through its managing director has undertaken to construct the collapse span by itself without any additional cost to the government. Undertaking by the managing director is produced through an affidavit dated so and so. A letter written to the additional chief secretary, road construction department. We extract paragraph 4 to 6 of the undertaking given. So this was the undertaking. Learned Advocate General also informs us that agency appointed was to have the design prepared through a consultant. The consultant was appointed by the agency, and the design was also sent for approval to an expert who was chosen by the state from a panel of 3 submitted by the agency. Only on expert affirmation, the construction was commenced, which has been stalled due to collapsing of certain spans, which had collapsed only on account of being extra dosed. As is the prima facie assumption as of now, the design would now be redone and remodeled with modified technology, and in any event, since agency has taken upon itself the liability insofar as building of the collapse span with no extra cost to the government, we are of the opinion that public interest litigation can be closed. So, my lord, there was a change of design also post collapse. So that is why my humble submission is, my lord, if an opportunity would have been given to us, we could explain this position. Whether the fault is attributable to us or whether the fault is attributable to the design. So it cannot operate in such, wide discretion, my lord. There has to be some checks and balance when it comes to conferring some power upon the authority. There is no dispute that as a proposition of law, it is difficult to make an argument that we are challenging a condition of tender. It's not that exactly, my lord. All that we are saying is, how do you operate it? How do you apply to a given facts? Look, can I place one Delhi High Court judgment precisely on the point? This is, I have the copy. এখন দেখো এটু হেরি দে 2018 SCC online Delhi 8269. Now the debarring clause here is para 7, my lord. Second page. The relevant condition of instructions to bidder which have been impugned in this case reads as follows. 2.1.18. Any entity which has been barred by the Ministry of Road Transport and Highway or its implementing agency for the works of expressways, National Highway, ISC and EI work, and the bar subsists as on the date of application would not be eligible to submit bid either individually or as a member of a joint venture. So this was the clause, my lord. Then eventually, if your lordship would kindly come to para 25. after referring to different decisions, including Eurasian chemicals and all, equipments at para 25. As a result of the discussions above, it is held that clause 2.1.19 of the tender condition is arbitrary and unreasonable to the extent that in the matter of a case falling under the said clause, it amounts to automatic debarring of the party from participating in any other tender bid taken out by NHAI for a period of 2 years without a hearing. The condition is therefore held to be applicable in other cases of termination if and only if NHAI or public agency affords the party a right of hearing against such disbarment, and second, the disbarment from participating in another tender due to tender termination in one shall be justified only after considering the merits of each case with respect to such other tender. The court is of the opinion that such a wide debarment condition is disproportionate in that it directs the authority of NHAI to rule out absolutely consideration of tenders and bids for a period of 2 years. Termination of a contract can be for various reasons. They may be at the beginning of the contractual period or at the fag end of the completion period. Given these variations, treating all contracts alike in regard to result of debarring, the private parties who might have not caused any or at least not caused substantial injury to NHAI's interest results in arbitrariness. So, my lord, if you want to apply such a clause without hearing, and the division bench of the Delhi High Court says it would be unjust and disproportionate and arbitrary. Hey, it has been written. My lord, this second judgment, Miller, Honorable Supreme Court, Miller. This is 2024 SCC Online Supreme Court 1896.
Justice Vishwanath.
Yes. If a lordship would kindly come to paragraph 21, Miller. After referring to B.N. Joshi, Puligia, etc., questions for consideration. The following questions arise for consideration. Whether in the facts and circumstances of the case, the order of the corporation dated 2/3/16 debarring appellant for a period of 5 years is valid and justified in the eyes of law. Para 22. Blacklisting has always been viewed by this court as a drastic remedy, and orders passed have been subjected to rigorous scrutiny. Then, my lord, Eurasian Chemical, B.N. Joshi, Kulija, and all these are referred. Then eventually at para 26 and 27, my lord, at page 20. In other words, where the case is of an ordinary breach of contract and the explanation offered by the person concerned raises a bona fide dispute, blacklisting debarment as a patent penalty ought not to be resorted to. Debarring a person, albeit for a certain number of years, tantamounts to civil death, inasmuch as the said person is commercially ostracized, resulting in serious consequences for the person and those who are employed by him. Too readily invoking debarment of ordinary cases of breach of contract, where there is a bona fide dispute, is not permissible. Each case do not would turn on the facts and circumstances there. So, my lord, merely because there was some incident of some collapse, some mishap, this power is not readily available, my lord. It is, this power is available with some circumspection.
No, no. Yes, But this is not a case of debarment by them. Otherwise, are you saying,
No, what I'm saying is, Milord,
no, are you therefore saying that whoever participates having a problem to the affair, they should be heard?
no, what I'm saying is, Milord, if a notice is given, then I can at least put my perspective. That is what has been denied, Milord. Therefore, it is arbitrary. End of the day, Milord, Lordship has seen the clause, it is open-ended. On the contrary, kindly see their conduct. Similar parties, Milord, having similar problem. In fact, they come within that mischief of 5 years. Just to save them, Milord, it was reduced to 3 years. And which they admit that because there is a change of management of L&T, therefore they expect them to behave what? Behave wisely. So, Milord, my humble submission is, it's a bona fide, it's something like when there is a bona fide right to litigate, you cannot invoke summary jurisdiction. It is something like that principle, Milord, that Devendeka's case. All that we are saying is, this is not clear, Milord, there needs to be some more clarity. When you want to invoke such district power, it must be absolutely clear. It must be, Milord, expressed in such a way that there is no element of any arbitrariness. There is no element of any discretion. It is consistent with Article 14. Hence, yes, well, I'm not saying such a clause cannot be there, but the clause must be with certain amount of clarity.
Have you explained in your petition?
Yes, we have done it. We have, yes, Milord.
Is there any finding of the department's concern?
No, no.
That this happened on account of
No,
something
Milord,
else?
my only submission is, Milord, if your Lordship kindly takes the first petition, I'll just show, Milord, from
I'm
page.
yet to take up the second because first, unless you satisfy the, then
No,
only I
Milord,
take
first,
the second.
in my humble submission, Milord, first I'm already protected.
No, you are not protected.
No, it says, Milord,
It says only that you are to be considered. They have considered.
no, Milord, they have considered, how can they reject it, Milord, without taking leave of the Honorable Court? When the court says, Milord, Lordship will kindly see, despite that clause, despite everything, when the Honorable Court says, you consider his case means you will consider on, that means you do everything, including my financial bid. My financial bid has not been opened.
Subject to further orders of the court.
Exactly. Normally what we understand in such a cases is, they will do everything including my financial bid, but they will say because of this reason, therefore the court will decide this petition, then they will give a call to their decision.
No, you approach at a time prior to submission of the bid.
No, we submitted, no? We submitted the bid, Milord. We apprehended that with the aid of this clause, they might reject our technical bid. That's why we
So
came.
did you submit the undertaking which is required?
Yes, that's
Where
what.
is the undertaking?
Yes. Please come to the second petition, Milord.
First petition.
No, first petition, Milord.
Because as per this, you are required to submit an undertaking. Has submitted an undertaking in this regard shall be submitted by along with the bid. Where is that? As per clause 2.2.2 or whatever.
Where is that?
Page 99.
One
Where
second.
is the undertaking?
Milord, we have not in the part of the petition, we have it, Milord.
No, did you submit that undertaking?
Yes. Yes, we have submitted before the authority.
You mean?
Sure.
Oh. That's all. We will have it tomorrow. Get your people, get them.
We'll give it, Milord. We'll give
Give it tomorrow. Give it tomorrow. Get that thing because that is the most vital thing.
Yes.
And did you submit? Therefore, the question is, well, how did they consider the undertaking is the question.
Milord, we'll place it tomorrow. No, my only a request, Milord, can it be taken by 2 o'clock, Milord?
Why?
Like 4 o'clock, I'll be leaving somewhere, Milord. That's why.
10:30.
4 o'clock or 10:30 is very well.
Tomorrow you will take it up. Tomorrow.
Up in the first half. Yes.
The first
Then
half?
I may be given the liberty to mention, Milord. Yes. Very well.
Taking into account that there is an affidavit filed by the railway authorities This court directs instant writ petition to be listed, both the writ petitions to be listed tomorrow.
My lord, we'll bring it by of an additional effort.
Liberty given to the petitioner to submit an additional pleading if so required. Itu have filed an affidavit in opposition in WPC number 5059/2025. Both the matters be listed tomorrow at the motion stage, taking into account that in WPC number 6274/2025. No notice has been issued. Liberty given to the petitioner to mention the matter for upgrading.
Deep level.
Item 18 for
So
motion.
give your instructions which you have received. No, the second one.
Second one.
You have got your instructions.
Second one, I have got instruction. Even also, second one, I relied on the RTF itself also.
No, it's okay. You have the instructions.
Second one also short one page instruction regarding.
Have that. Give it to him. You have a look at the instructions in the second matter.
Yes. Deep level.
May it please your lordship.
Yes, what is this?
Well, it pertains to a tender process, my lord. Well, very precisely, my lord, the fact is the NIT was issued by NHIDCL.
Whom did you serve the copy?
Well, I served the copy, my lord, the day it was filed, day before your study.
Huh?
Day before your study. Day before your study, my lord.
To whom?
Huh? NHIDCL.
Okay, what is the point?
Well, the point is this, my lord. My lord, there were two bit system of tender, my lord. Now, after submitting all these documents, my lord, when the technical bid was published, my lord, where respondent number 4 was disqualified, only the petitioner along with another one was qualified, my lord. But thereafter, this particular publishing of this list, my lord, was deleted, and later on, my lord.
How do you say disqualified?
My lord.
Annexure 2.
Yes, lordship.
What is the respondent number 4's name?
This Kamakya Travels, my lord.
Okay, they have been disqualified.
Qualified, my lord, disqualified. But
Then?
later on, my lord, this disqualified bidder, my lord, has been declared as L1. This is Annexure 3, my lord.
Annexure 3.
Page 46. Page 46.
And you are number?
I'm L2, my lord. Serial number 2, my lord.
Travel service.
Travel service, my lord. This is the case, my lord.
So you are therefore saying that when a disqualified member, how is he becoming L1?
My lord, even in the
Have the contract been given to anybody?
No, not yet, my lord. Not yet. Even, my lord, their tender document very precisely reflects that once a bidder is disqualified on
No,
technical.
but have you surveyed to the
My lord.
NHIDCL? Does he have a standing counsel? They have a standing counsel.
It is there.
It's the R.K. Talukdar or Mr. C. Bolwa, they appeared for them. Have you served anybody? Or you have only served the DSCGI?
No,
Because they are otherwise very vigilant in getting an order, means of protecting them. Hey, Econ second file, please.
it was filed, my lord, because it has already been there in the cause list.
No, the name of the department SGI is there only.
Okay. No, there is another. None is there, my lord, in the cause list itself. I said, it is there, my lord.
Same person has received.
Yes, my lord. it is
For
there.
both.
My lord, it is there.
How is it possible? How can for DY, SGI and for NHIDCL, same person can receive? It's impossible.
There was, at the
It
time.
can be only received for union is different than India.
No,
Where is that person, NHIDCL?
my lord, when it was
Whom
filed.
you serve?
My lord, when it was filed, my lord, there were some objections by the registry, my lord. And thereafter it was rectified by filing another copy to the respective.
Whom did you
sending officer.
serve?
Just other boys there, my lord. Let us confirm, my lord.
Because, no, I'm saying because
My lord, I understand that.
both the persons is same. It can't be. No, here, you don't see it. Can't be. Same person is receiving for both. It can't be. Because they are not central government councils.
Or the man who is designated to receive, my lord, he is the one fellow. He receives it.
You must
He
have
receives
given it out there for both.
No, in the office, my lord, in the government.
For office, they don't take, nah, because you see, C. Borua and Mr. Arke Talukdar, or there's another person. These three persons, they do not, they are not central government councils,
True, my lord.
isn't it?
They took into.
Huh?
Yeah, indeed.
What is his name?
2%. The same person.
Oh, yeah.
Okay. Okay.
Yeah.
There might be some sort of confusion, my lord, because my junior says that.
You serve a
Sir.
copy to who is otherwise available mostly? Yeah? No, there was no. Okay. Serve it to any of these persons. Take it up tomorrow.
My lord. My lord.
So it is seen that none has appeared on behalf of the NHIDCL who has standing councils. This court has further taken note of the notice, and it appears that one person have received on behalf of both the union government as well as for NHIDCL. However, taking into account the above, list this matter tomorrow for motion, indicating the name of Mr. C. Burwa. A copy of the writ petition be served upon Mr. C. Burwa during the course of the day.
My lord, deeply obliged, your lord. We'll file it.
Production list item 1 for motion.
Well, some difficulty arose, my lord. What happened, my lord? I wrongly mentioned, my lord, because GMD all matters are here, but demolition matters are bench 5, my lord.
Huh?
Bench 5.
Oh.
So, my lord, filing section asked me, my lord.
What is the matter about?
My lord, yes, demolition of the building, my lord. Here, what happened, my lord? They have.
Demolition.
Yes,
Demolition is, I can take it.
yes, my lord. So,
I can take up demolition,
demolition, yes.
GMC.
Well, but GMD council is not here, my lord.
Have it tomorrow then. When are they demolishing it?
Monday, my lord.
Monday, time is there.
They have already issued notice to all the, my lord, my lord, concerned departments.
Okay, please the matter tomorrow. For motion, showing the name of Mr. P. Naik, standing counsel of the GMD.
For admission item 2.
May it please your lordship, my lord. The order and the challenge, my lord, this has been recalled by my lord, the district and session judge, my lord. To that effect, my lord, I have filed one affidavit today, my lord.
Oh, that one day.
Yes, ma'am.
My lord, here, my lord, we have to file the affidavit, my lord, which is ready, my lord. Tomorrow or Monday we will file, my lord. Let it be on next Thursday.
Mr. G. Bushro submits the affidavit on behalf of the respondents. Thought it could not be filed today and could be filed by tomorrow positively. To list this matter again on 20/11/2025. The affidavit on behalf of the petitioner would be at liberty to file any reply. So advised.
Item 3,
Oh, where is the GNRC? None appears on behalf of the parties. Accordingly, list the matter again on 9th of November 2025.
supplementary item 20 to 25.
This, Mr. Pathak, your matter, you're just, what are you doing? This not your matter, 20 to 25.
My lord,
Then this court have to call the advocates also. This has become the norm now. Where's, who appears for the High Court?
Mr. Das,
20 to 25, na?
20 to 25, my
What
lord.
is your stand?
Some instructions relating to the rules.
Mr. Nayak, there was a demolition matter. I fixed it tomorrow,
Yes.
as you were not present.
Lordship. Lordship tomorrow.
Tomorrow, promotion.
Lordship, yes.
Sorry. Well, in item 20, the stand is that he has not
25 on last.
adhered to the timeline spelled out in the draft gradation list. That is 15 days for filing objections. He has done it after 9 months. Paragraphs 6 and 7.
Your item is what?
25, my lord.
This is item 20.
20. These are all matters pertaining to the problem as regards the
The rules and the notifications.
the
my
rules
lord.
and the notifications. Yes, what has happened? Where is the government? And the High Court. You are for the High Court. Do you know anything about the rules?
That the instruction I don't have.
Then what are you appearing for?
Well,
The issue is, this court is taking up the issue as to what has happened to the Assam district and subordinate court employs rules, service
whether
rules.
the Assam government has
Notified it or not.
notified it or not. Well, that my learned colleague is.
She won't know. You will be knowing. You are the High Court.
That, well, I don't have instructions.
You are not appearing in this matter, maybe because of that. It's Mr. H.K. Das who was appearing.
The other matter.
Yeah,
নিকুঞ্জ ফোন কৰি
That state of affairs.
নিকুঞ্জক এটা ফোন কৰি দিয়ক
Another.
নিকুঞ্জ মাতে নিকুঞ্জ কৰে নিকুঞ্জ আছিল না
Mr. Pathak, there is sorry that the High Court Council doesn't know, as well as the State Government Council doesn't know. But there has been certain substantial progress in
Hello.
these rules. And I think it will come up by this year.
that we
There is
are
some
privy to, my
meeting
lord.
fixed on 11th of November. And I think it will be done, scratching out with the Legislative Assembly department has
My
been
lord.
done. We have, the High Court have already made this correspondence.
It's in the very
So,
final stages.
Let's have it on 20 for an update,
Hello.
27 for an update.
27.
27.
It has been submitted by Ms. S. Sharma appearing on behalf of the Guwahati High Court. That pursuant to the orders being passed by this court, the High Court of the administrative side have looked into the rules, the draft rules which have been placed by the Legislative Assembly, by the Legislative Department of the Government of Assam, and have also submitted the respective comments to the Legislative Department. The Legal Council submits their further update can be given in as much in a 2 weeks' time, taking into account that there is further deliberation on the administrative side taken up. done. List accordingly on 27/11/2025 for an update.
Today's cause list, my lord, shows that there is a status report in seal cover. There is a status report, my lord, in seal cover. The cause list indicates so. But
For what?
maybe in this matters, my lord.
What status report? Oh, that
That,
one.
that is indicated in the cause list, but it's probably with Mr. Das only as well. Obliged, madam.
For orders item 4.
Lordship, in this matter, we have just received the instructions, Lordship.
Yeah?
Kindly
Why no affidavit file?
Kindly sometime may be given because the last instruction that we received did not contain any signature and the instructions was there in the office, but we didn't receive it, Lordship. We just received it today, Lordship. Kindly sometime may be given to file the affidavit, Lordship.
What's your name?
D. Mohan, Lordship.
You are standing counsel of the High Court.
On behalf of Mr. H.K. Das, Lordship.
HK Das is not there.
The High Court matter, Lordship, in book number.
Ms. D. Mohanta, appearing on behalf of Mr. H.K. Das, standing counsel of the High Court, submits that further instructions have been placed, and as such, the draft affidavit has been prepared on the basis thereof and has been sent for vetting. List the matter on 27/11/2025. In the meantime, the High Court, the respondent parties are directed to bring on record their stand by filing the affidavit on or before 24th of November 2025 without fail.
All right.
Order do it. I think I think there was a hearing no. Okay. Mr. Gupta, there was some matter which was. Oh, what matter is yours?
Partner matter also.
Which one?
We have challenged the labor court order also.
Huh?
Labor court industrial dispute matter also.
Which
And
one?
and item number 5 also.
Asiatic.
Yes, Lord.
What happened?
Lordship,
Yeah,
in terms of Lordship order, we have filed additional affidavit, Lordship, bringing those documents, Lordship, pursuant to the BFR order, Lordship. And in fact, Lordship, all the employees has resigned from the service in the year 2004, Lordship. At best, Lordship, if Lordship held in favor of the respondents also, he would get back wages till 2004, Lordship.
Because they have resigned.
All the employees resigned, because the unit also closed and all the employees resigned.
So there will be a question of payment of back wages.
Back wages and Lordship, we have pursuant to his dismissal, Lordship, 17B was paid till 2012, Lordship.
So then no payment is required.
Yes, Lordship.
Yes.
So he has
You
to
seen
take
the
it.
additional affidavit. You are better. You are any day better. Then you can't get anything. They are closed. BFR
Yes, Lord.
declared sick.
Yes, Lordship.
No,
And Lordship,
no rearrangement.
If Lordship peruse the page 100.
And they resigned in 2004.
All the employees, Lordship.
So you are not going to ask that money from them.
Lordship, 2012, but during the proceedings, since we have to pay the 17B, because this honorable court's order direction was there to pay the 17B.
So you paid till 2012.
2012. And thereafter, the matter was remanded back and subsequently again pass order in our against.
Against you.
Against.
Chalo. When did you file the affidavit?
On 18/8.
What is your instructions?
Not contact the client also.
Obviously, 2004 they have resigned. But have you enclosed those documents?
Yes, Lordship. All the employees, except the respondents, others employees documents are there.
Except the respondent?
Because respondents, Lordship, we have in respect to respondent, Lordship, we have already his service was already retrenched, Lordship. In respect to his.
He was retrenched?
Yes, Lordship.
When?
In the year 2004 itself.
He got his benefits?
All the other benefits got, Lordship. And other unit was also closed. All the employees were resigned, Lordship. So no one is there, Lordship. So therefore, at best he would get from till 2004 back wages, and we have paid.
Okay. It has been submitted by the learned counsel appearing on behalf of the petitioner that an additional affidavit has been filed on 18/8/2025. Mr. H. Gupta appearing on behalf of the respondent shall obtain necessary instructions to list this matter on 20/11/2025 for final disposal.
Hello.
Any more thing? No. Okay, over.